Thank you, Mr. Chair. I just wanted to take 1 minute and recognize a very special guest I have with me here today, my mother, Cindy Garland.
No worries. Yes, thank you, Senator Gannon. Thank you, Senator Gannon. Thank you, Vice Chair Gannon and honorable committee members. My name is Deborah Altschuler, and I represent Senate District 24, which includes the towns of Exeter, Greenland, Hampton, Hampton Falls, Northampton, Rye, and Stratham. In New Hampshire, the very first words of our Constitution in Article 1 are all men are born equally free and independent. That is a truly inspiring ideal. That article was adopted on June 2nd, 1784. At that time, the use of the noun men was a very specific choice. The population of New Hampshire in 1784 was roughly about 87,800 people. And it wasn't all men. Women were here then, as we're here today. We've been here all along. That first article, that Declaration of Freedom and Independence, is followed by Article 2, entitled Natural Rights. All men have certain natural, essential, and inherent rights, among which are the enjoying and defending of life and liberty. In 1974, New Hampshire citizens amended Article 2 to add a sentence saying, equality of rights under the law shall not be denied or abridged by this state on account of race, creed, color, sex, or national origin. In 1972, unlike in 1784, women had the opportunity and the right to vote on that constitutional amendment. In November of 2018, 81% of New Hampshire voters approved adding 22 more words to our state's constitution, adding Article 2B, a right to privacy, an individual's right to live free from governmental intrusion in private or personal information is natural, essential, and inherent. This amendment was about control and who has it. New Hampshire citizens changed the Constitution to ensure that they had control over their private and personal information. CA-CR 24 would add 31 more essential words as Article 2C of the Constitution. The right to make personal reproductive medical decisions is inviolate and fundamental to the human condition. Neither the state nor any political subdivision shall infringe upon or unduly inconvenience this right. 33 words. This amendment, like Amendment 2B, is also about limiting government intrusion in our personal lives. This amendment grows naturally out of our existing Constitution and our statutes. Listen to the language of Chapter 137J, which is titled Written Directives for Adults Without Capacity to Make Medical Decisions. In the purpose and policy statement says, 1, the state of New Hampshire recognizes that individual persons have the right founded in the autonomy and sanctity of a person to control the decisions relating to the rendering of their own medical care. The New Hampshire legislature has amended this chapter 3 times and consistently reiterates the purpose and policy that the state of New Hampshire recognizes that its citizens have the right founded in the autonomy and sanctity of a person to control the decisions relating to the rendering of their own medical care. And yet, when that New Hampshire citizen is pregnant, their rights to control decisions related to their medical care and the privacy of that personal information is interfered with by the state. Pregnancy is the line where constitutional rights are stripped away. Article 1 again says all men are born equally free and independent. Therefore, all government of right originates from the people, is founded in consent, and instituted for the general good. There's no caveat written into Article 1 that says, no asterisk that says all men are born equally free and independent, except when pregnant. And yet the loss of freedom and
Boom, boom.
Thank you very much for your testimony, Senator. Are there any questions from the committee? Senator Gannon?
Thank you, Madam Chair. Thank you for taking my questions. Is it working this time? Yes, good. Thank you. Under Casey, the state says that it has a compelling interest in protecting the life of an unborn. So we're not going to argue here what week or when, but do you agree that the state does have an interest as founded in Roe and subsequently in Casey, that we have an interest in the life of an unborn child?
Thank you for your question, Senator Gannon. I would point you to Article 1 of the New Hampshire Constitution, that all men are born equally free and independent. So the argument here is, does the government have a right to tell a pregnant person on an arbitrary day that they are no longer capable of making their own independent medical decisions? And this constitutional amendment says no, that the government needs to get out of the business of making reproductive health care decisions for the women of New Hampshire.
So you disagree with the Supreme Court of the United States precedent that the state does at certain points have compelling interests in a child at a certain point.
I would, hello, back on. Just as a reminder, the Supreme Court has turned all of this conversation, all of this debate, any protections that may have existed to the states. It's our responsibility and our job to debate this in this space, in this state. And our Constitution, New Hampshire, says that we are all born equally free and independent. And so if I am not free to independently make medical decisions that are best for me, then I am not free at all.
Follow? Thank you. Thank you for answering. At what point would you say, or would you not say, so you're going to allow abortions from week 24 up to birth? Is there a point when you're going to say that the child itself has a right to life the week before, 2 weeks before its birth? Or are you saying it's a woman's right up till the date of birth?
I'm actually so glad that you asked me that question in that way, because again, the right for people to make their own independent medical reproductive decisions should be inviolate. It is inherent to our natural and essential rights. The government should not be debating our medical decisions. We can make those decisions for ourselves, and the supposition behind when should the government get involved has behind it the thought that, or the assertion that the government has to get involved, because at some point a pregnant person can't be trusted. And so because they can't be trusted, the government needs to insert itself at some point. And if we have natural, essential, and inherent rights, then we can make those decisions for ourselves.
Follow up?
Follow up?
So you feel that in the 6th month, 7th month, 8th month, 9th month of pregnancy, that you don't think the child itself has any rights a week before its birth date, 2 weeks before, a month before? You talked a lot about rights, individual rights. Does not an unborn child in the last month of pregnancy have some rights on its own? Or you're saying it's never has any rights?
So the question,
You would allow abortion up till birth?
the question presupposes that the government needs to get into a pregnant person's health care during their pregnancy at a particular point, because they can't be trusted to make those decisions for themselves. Decisions that are incredibly personal, decisions that can be heart-wrenching, decisions that involve medical professionals, decisions that we have heard from women in the Granite State over and over again, that they need the autonomy to make these decisions for themselves with their healthcare providers, that the government really has no role in that. So natural, essential, and inherent right to your bodily autonomy to make the healthcare decisions that are right for you.
Final follow-up?
Okay, final follow-up, and then.
So again, just so I understand crystal clear, you feel that the child never has any of these rights at the 7th month, 8th month, when it's a viable fetus, that if we had to perform a C-section on a pregnant woman who got in a car accident, it could be an independent life. That child never at any point up till birth has any of its own individual rights. It's just the mother, never at any point the child. And so would you also allow
Senator Gannon.
abortion of like Downs? You're going to have selective abortions? Can people abort because they don't want a female baby like in China? Is that where we're heading?
So it sounds like that you would like to head in a direction where there's lots of control, because you've given me 3 examples that you find objectionable. And I would again refer you back to the Constitution that we all swore to uphold, that every citizen, everybody in this room, everybody in this state is born equally free and independent. And if you don't believe that some of the people in New Hampshire are equally free and shouldn't be independent because the caveat on our constitutional rights is pregnancy, that's a different conversation.
No, you asked me at what point I believe up to.
I did
It
not.
would be-
I did not ask you that.
Okay. It's just my difference with you is I believe that a child, certainly in the later months of pregnancy, has those rights that you're talking about, and you don't. So that's where we differ.
I did not say that either. Please don't put words in my mouth. I'm saying
Replay what you said. That's what you said.
that's not what I said, but thank you.
Thank you. Senator Habitz.
Thank you. Just a question on the terminology. Is this intended to apply as drafted only to abortion or just reproductive health, a much broader category?
I'm sorry. Thank you, Senator Abbas. Did you just say, does this apply to abortion and reproductive health care?
I'll rephrase it. Is
Okay,
it
thank
the
you.
intended language for this to be limited to the narrow scope of just abortion, or is it intended to apply to the broader category of reproductive health?
So the constitutional amendment says that an individual's right to personal reproductive autonomy is central to the liberty and dignity to determine one's own life course and shall not be denied or infringed. So very clearly, personal reproductive autonomy. Yeah.
A follow-up?
Follow-up?
Would you agree that would include abortion, but would that include other medical procedures in addition to abortion?
I can say, here's where I can meet you in that question, I think, is that at this point, today, in 2024, we have much more available to us in the realm of reproductive health care than we did in 1970, than we did in 1920, than we did in 1784. It is an evolving medical field. So reproductive autonomy right now, part of your reproductive choices involve birth control, involve contraception, involve abortion health care, involve perinatal and prenatal care. So reproductive autonomy applies not only, it includes IVF, for instance. It includes men and women. So this is, in the short, yes, but in the scope, it's much larger. And we don't know what reproductive health care will offer to men and women in 10 years, 20 years.
Thank you.
You're welcome.
Are there any further questions? Senator Whitley.
Thank you, Madam Chair. Thank you for taking my question. I would agree with you. You rightly indicated that the Dobbs decision decided by the U.S. Supreme Court now over a year ago completely removed the federal constitutional right to protection, and additionally the framework that Roe had set up that just doesn't exist. And furthermore, said that it is up to state elected officials now to decide the new framework. You also mentioned something about trusting women. And would you agree that that is particularly important because pregnancy is so complex, because pregnancy is so unique. My pregnancy was certainly very different than Senator Chanley's pregnancy. That was very different than Senator Carson's pregnancy. So when you said we need to trust women to make their own decisions, is that because of the unique situation, the unique medical situation each woman encounters in pregnancy?
Thank you for the question, Senator Whitley. I think if we have been listening, even in a cursory way, to the disasters that have happened across the country since Roe fell and no longer exists, so it is not a standard anymore. And now states are reinventing the wheel, and some are doing a better job than others in maintaining rights for their citizens, that if you've met a pregnant person and heard a story about their pregnancy. You've met one pregnant person and heard one story about one pregnancy. It's unique, it's dangerous, it can be amazing, and it can be life-threatening, but you don't know. It's not a given.
Thank you.
Are there any further questions from the committee? Seeing none. Thank you very much, Senator, for your testimony.
Thank you. Thank you for the opportunity.
Ma'am, there's a lady, ma'am, you're sitting in the aisle. That creates a fire hazard. You can't have people sitting. I apologize. I see that here every seat is full, but hopefully after folks testify, they will leave, so that way you don't have to sit on the floor. Okay, the chair will call Dr. Is it OG Young? Og, okay. Good afternoon.
Good afternoon. Thank you for I think I know most of you here.
Mhm.
My name is Dr. Og Young, and I'm here to support.
Dr. Young, turn on your microphone.
Yeah.
that?
You have to hit the button, sir.
Okay. My name is Og Young, Dr. Og Young, and I'm here to support CACR 24. I'm a retired obstetrician gynecologist who practiced in Concord and taught Dartmouth medical students for over 40 years. I am a past president of the New Hampshire Medical Society and continue to serve on our general council as a representative of all the obstetricians in our state. My older partner was a staunch, politically conservative Republican. When I came to Concord with my wife Pam and my 3 sons after just completing my residency in OBGYN, he smiled, looked at me and said, "I'm glad to know you need a job so badly." So we shook hands over an agreement of a $35,000 starting salary, and I have been forever grateful. It was a great privilege to practice medicine with such a beloved physician in this community. His career lasted 50 years. He deeply respected women, and I suspect that started with his mom, who raised 5 sons in Barry, Vermont, as a young widow. His father had died of lung disease working in the granite quarries, like many young men died. He was only 6 years old at the time, and from what he told me, he remembers his mom buying a broom and riding it hard. He attended the University of Vermont on a full scholarship where he lived in the Episcopal diocese. He was a devout Christian and remained a devout Christian his entire life. When Concord's St. Paul's Church sanctuary burned to the ground, he spent much of his time and treasures rebuilding it. He cherished his church. After college, he completed medical school at the University of Vermont and then did a rotating internship and finally spent 2 years in the Air Force at Loring Air Force Base in northern Maine. When he arrived, they asked him if he wanted to be their obstetrician or their pediatrician. And I remember him saying to me, you know, I preferred screaming women to screaming kids. So I chose to be their obstetrician. And it was there he found himself falling in love with caring for women and delivering their babies. And so he went on and did a 4-year residency as an OBGYN specialist at Women's Hospital in New York City. It was there during the late 1950s that he saw many young women die of overwhelming infection after they had had an illegal, botched back alley abortion. Many of those women left children at home as orphans. It became clear to him that abortions must be safe, made safe, and legal. He argued that women will always desperately seek abortions, whether it's legal or illegal. The unnecessary deaths that he witnessed during his training left a mark on his heart, mind, and soul. It was plain to him that abortion should only be performed by skilled physicians in sterile conditions. The U.S. Supreme Court Roe v. Wade landmark decision in 1973 was a great relief to him. Besides delivering thousands of babies, days and nights, he provided safe abortion care in our office, at Concord Hospital, and at the Feminist Health Center, now called Equality Health Center. Motivated by what he had experienced during his training, he stayed intent on making a woman's decision not to carry a pregnancy private and safe. I often asked him, how can you vote for a Republican candidate who is openly opposed to abortion? And his answer was always the same. He'd say, "Oh, abortion is not a political issue. Abortion is about health care, safe health care for women." Few people knew better than he. His feelings never wavered, even when protesters threatened him in our office and threatened him at home. He would be appalled that politics crept into the judicial branch of our democracy. In the Dobbs decision, which reversed Roe v. Wade in June of 2020, he would find it hard to believe that after 50 years, the right to privacy and safety in deciding about a woman's health, her family, and her future was taken away from her. He knew that the decision to terminate a pregnancy is deeply personal, one that deserves to remain with each woman and her care provider. That medicine is about caring for human beings, not about politics and ideology. He believed that everything we can do to give women control of their bodies and their fertility enhances their health and their freedom and changes the world for the better. If he were still alive, he would be sitting here with me and urging you, as I am, to enshrine women with the right to have an abortion. I ask you to support CACR 24 and amend our New Hampshire Constitution for the sake and the safety of women. Thank you.
Thank you very much for your testimony. Are there any questions from the committee? Senator Gannon.
Thank you. Thank you for taking my question. So you're probably very familiar with the law we passed a few years ago, 24 weeks, exceptions for the health of the mother, fetal syndrome anomalies, probably something else I'm missing in there. So were you happy with that? And do you see a distinction now with this new amendment? It would allow a late-term abortion, as far as I can see, of 7, 8, 9 months. We had a 24-week period that seemed to be accepted by 80% of the populace, seemed to be very popular. It seemed to be the best consensus. Now we're moving extreme to right up to birth. So I agree with you in a lot of ways that abortion may be necessary in some circumstances. But now I see we're going very far the other way, way beyond what Roe had.
I really object to you using the term abortion after 24 weeks. That is not an abortion. That is a birth. And that is a medical question.
Excuse me.
That's not a political question.
Sir, gentlemen, we are not going to do back and forth here today. I know that this is a very emotional issue for many people, but that type of conduct will not be allowed in this committee room.
What
Thank you.
won't be allowed?
The back and forth.
I
And
apologize.
that's
I'll be.
both of you.
Okay.
That, we've got a lot of people here who would like to speak, and we're not going to take up time with the arguing going back and forth.
But one of the big problems I have with that Fetal Protection Act is it still criminalizes physicians. Makes it very difficult for maternal fetal medicine specialists to make a decision about terminating a pregnancy when a mom's health is at risk, when there's a fetal diagnosis. Those things are not black and white. So I do have a trouble with that.
Are there any further comments or questions? Okay. Seeing none, thank you very much.
Thank you. Thank you for your question.
Thank you. Is Mr. DeJoy here in the room? Because he's signed up and I'm not sure if he wants to speak. He didn't check any. I don't know. It's just at some point, if he's out there, he just still needs to let me know. Okay, next we are going to hear from Laura Gandia. Is she here? Okay, here we go. Okay. Before we get started, and I unfortunately could not be here when the hearing started. I had another bill, one of my prime sponsored bills that I had to introduce to the committee. We have a lot of people here today that want to speak on this particular issue. I want to be very respectful of individuals. Everyone has a right to their opinion. I don't want to see people attacking each other. Let's get through this hearing. So in order to do this, I'm going to ask everyone, please, if you have written testimony, do not read it verbatim. We want to make sure everyone has an opportunity. Please do not repeat things other people have said. We would definitely appreciate that. And if we get too far behind, I'm going to institute what I call the 3-minute rule. Everyone will have an opportunity to come forward to speak, but everyone will be limited to 3 minutes. I want to make sure every person here who has signed up to speak has the opportunity to speak. So please work with me on this and we'll get through this hearing this afternoon. Thank you very much. Ms. Gandia.
Thank you. Good afternoon, members of the committee. I am Laura Gandia, representing Cornerstone Action, and am speaking in opposition to CACR 24. The Constitution is not, nor should it ever be used as a political pawn. Amendments to the Constitution should seek justice for the benefit of the common good, should unite us as free people, not divide us. The weaponization of the New Hampshire Constitution, as outlined in CACR 24, tears at the very heart and soul of our republic. We are called to promote charity and human dignity for the common good, a common purpose. For the Constitution to serve its purpose, it must act as a coherent, unified working document. Any amendment should echo and support its purposes. An amendment cannot survive if it disrupts its continuity or conflicts with other provisions. CACR 24 represents challenges as an unconstitutional amendment. Some scholars insist that amendments must be harmonious with the body of the instrument. Another argued, if an amendment leaves a constitution in such a state that it is a smoldering, meaningless wreckage and internally inconsistent, then such amendment should be declared unconstitutional. In the Dobbs decision, the court noted that the Constitution makes no reference to abortion. No such right is implicitly protected by any constitutional provision, and abortion in and of itself is contrary to the spirit and intent of the Constitution. The court recognized that there are rights not explicitly mentioned which can garner constitutional protection via the 14th Amendment or otherwise, provided such rights are deeply rooted in the nation's history and tradition and implicit in the concept of ordered liberty. Reproductive autonomy is not a right contemplated by the Constitution or the 14th Amendment. It is neither deeply rooted in our nation's history or implicit in the concept of ordered liberty. It is critically different from any other right that the U.S. Supreme Court held worthy of liberty protection. When the 14th Amendment was adopted, 3/4 of the states made abortion a crime at all stages. Our Bill of Rights, Article 1, states as part of its purpose, all government is instituted for the general good for all. Article 2 calls for the protection, enjoyment, and defense of life and liberty. This CACR defies and conflicts with these articles, creating dissension, discord, and inconsistencies. There is no rational basis for the institution of this amendment or how it is central to liberty and dignity. Even if someone believes that reproductive autonomy is a right contemplated by the Constitution, a look at Article 3 of the New Hampshire Constitution dictates the hitting of the brakes. Article 3 of our state constitution provides when one enters into a state of society, they surrender up some of their natural rights in order to ensure the protection of others. The others can and should clearly be viewed as the children in our society, to include those living in the mother's womb and to whom the sponsors of CACR 24 now seek to avert their constitutional obligations and duties as sworn member of this legislature to protect under the guise of reproductive autonomy. CACR is internally inconsistent and diametrically opposed to the purposes and framework of the New Hampshire Constitution, fails to defend life and liberty for all, and to provide for the protection of others. A vote of inexpedient to legislate is the only proper, just, and appropriate action.
Thank you very much for your testimony, Ms. Gandia. Are there any questions from the committee? Seeing none, again,
And I
thank
do
you.
have a written.
Yes,
copy.
please, you can give it to Mr. Shelzy and he'll make sure we get it. Thank you. Okay, next we're going to go to Dr. Richard Johnson. Good afternoon, Doctor.
Good afternoon. Thank you, Madam Chair and members of the Judiciary Committee. My name is Richard Johnson. I'm a New Hampshire physician. I live in Dunbarton. I'm not here to deny reproductive rights. By that, I mean the right to decide to conceive or not conceive a child. In the rare instances of anguish of life of mother versus life of child, I vote for the mother. We live in a world of violence, disease, and you will hear testimony of heart-wrenching cases of suffering where there's no easy answer. Those situations are the world of medicine, not of politics, and those situations are rare. What I would like you to consider is this. 42% of all pregnancies in the United States are unintended. There are 1 million abortions a year in the US, 2/3 of which occur during the first 8 weeks of the baby's life. These are the reasons that are given. The timing was bad. I'm not ready to raise a child. I want to focus on career or school. The solution to unintended pregnancies is not unrestricted abortion. The solution is to focus on prevention, vigorous education, and easy access to birth control, counseling, support of women during pregnancy, so they will not lose their job or their education. We need to show the same care for the preborn citizens of New Hampshire as we want for ourselves. I found only one legislative bill for the 2024 session that offers help to the woman during her pregnancy. We should have the compassion and social will to do better than that. If abortion were allowed with no restrictions, many of the problems that you will hear about today would be solved. Two problems would remain. One would be the moral injury of living in a society that condones such a practice. The second would be, how do we value the sacrifice these babies, these developing babies, made for our own personal peace and happiness? I would urge you to vote inexpedient to legislate. Thank you very much.
Thank you very much, Doctor. Are there any questions from the committee? Seeing none, thank you for your testimony.
Thank you.
Okay, looking for some of the reports. Okay, next, oh, Mr. DeJoy isn't here. Okay, next is Mr. Lacoste. Good afternoon, Mr. Lacoste.
Good afternoon, Madam Chair, members of the committee. My name is Robert Lacoste. I live in Stratham, New Hampshire. I've testified before you folks before. I am a retired nurse anesthetist. I practiced for 29 and a half years, and I oppose any effort or attempt to facilitate abortions. Approximately one half of all babies conceived are female. Who is protecting their reproductive autonomy? As I read your note here, the printed Article 2C, parentheses, reproductive liberty, it reads that an individual's right to personal reproductive autonomy is central to the liberty and dignity to determine one's own life and shall not be denied or infringed. At conception, an individual has all the components, the genetic components, to be considered a human being. As a practicing nurse anesthetist, I cared for many women during my career, and some of the cases that I did anesthesia for were for ladies who had miscarriages and had retained products of conception. That is a very challenging thing for everybody, for the doctor, certainly for the patient, and for anesthesia. Part of anesthesia's role during the procedure is to estimate blood loss. We have to look at the canisters that the doctors are suctioning materials into. And I've been retired for 10 years, and if there's one thing that I remember distinctly is in a case where we were doing where the doctors were removing products of conception, how disturbing it was to look at the canisters and know that not only was there blood in there, there were parts of a human baby. And I just can't imagine what an abortion looks like. I never participated in an actual abortion, thankfully. The other thing I will say is the government has to protect all human beings. If a human being at conception, or if a baby at conception has all the components to be considered a human being, and we know that they do, the government has a role. And as the good doctor over here stated, medicine is about, quote, caring for human beings. And I'll keep it brief and ask any questions.
Thank you very much, Mr. Lacoste. Are there any questions from the committee? Seeing none, thank you very much.
Thank you for the opportunity.
Next, I'm going to call Liz Canada. Good afternoon, Ms. Canada. It's good to see you again.
Good to see you too. Happy New Year.
Happy New Year.
Well, thank you, honorable members of the Senate Judiciary Committee. I'm Liz Canada. I'm the Advocacy Director at Planned Parenthood New Hampshire Action Fund and Planned Parenthood of Northern New England, and we're here in support of CACR 24. After the U.S. Supreme Court overturned Roe v. Wade and Casey in June 2022, 6 states have had abortion explicitly on their ballots: Vermont, Kansas, Kentucky, Michigan, California, and 2 months ago, Ohio. 2 of those measures were to further restrict abortion, and the other 4 were to put the right to abortion in their state's constitution. Now, those states have very different processes than New Hampshire does to amend their constitution. Some of them are able to collect signatures to have a ballot initiative. We don't have that in New Hampshire. But what I want to make clear is that for all of the states, voters came out in strong support of abortion rights in all 6 of them. And those 6 states are very different from one another. Because reproductive rights, abortion, and birth control are all bipartisan supported issues. They're not red issues or blue issues. It affects all people in our state. Here in New Hampshire, for so long, we have enjoyed broad bipartisan support of abortion rights and reproductive freedom. CACR 24 would send this question to the voters. Like we heard earlier, I believe, from the prime sponsor, it would give the opportunity for the voters to make that decision. That is the responsibility of legislatures now that Roe v. Wade is gone, now that the Supreme Court had ruled in June of 2022. I know that it is a high bar to amend the New Hampshire Constitution, but the vast majority of the voters want to see this happen. They want to see abortion rights added to the Constitution, and they want their state lawmakers to take that action to send them that question. So we are here in support of CACR 24. Thank you.
Thank you very much for your testimony, Ms. Canada. Are there any questions from the committee? Senator Whitley?
Thank you, Madam Chair. Thank you for taking my question. I think you made an important point about, what we have in front of us today. This isn't a typical piece of legislation. This is a CACR. So would you agree that, if a senator voted yes in support of the CACR, that doesn't necessarily mean that they would even vote for this to be added to our Constitution. Is that correct?
Yeah, I completely agree. It's really about sending, of course, if you vote yes, I would want you to, of course, support abortion rights. But it is about sending it to the voters. Like, the only way that New Hampshire voters get that opportunity is if the legislature sends it to them. I know that there's a constitutional commitment like that. There's that path too. But truly, this is the path to get it to the voters, is to send it through a CACR, which, and this is more for the other folks in the room, it's a higher bar. It's higher than it is for a regular bill, but it's such an important thing to send to the voters.
Follow up?
Follow-up?
I think that's an important distinction, and thank you for raising it with us. You were part of the conversations when we tried to codify the right to abortion in our state statutes. And I'm wondering, if you heard during that conversation, well, we're just not comfortable with it in state law, let's send it to the voters. Let's, put it to the voters to decide this issue. We don't feel like we can decide it. Did you hear that?
Yes, I heard that. I know I'm not supposed to speak of the other chamber, but I heard that in both chambers from folks on both sides of the aisle, that maybe they disagree with this, as you said earlier, but they want to hand it over to the voters to give them that opportunity. Absolutely.
Last follow-up?
Follow-up?
How popular is it in New Hampshire? I know it's popular, across the country. It is a winning political issue. We know that in red, blue states. We've seen that with these 4 states that have added the right to abortion in their constitution. How popular is, actually putting protections in the letter of the law, the Constitution, or legislation? How popular is that in New Hampshire?
Thanks for the question. Extremely popular. So I believe it's 87% of voters want to see New Hampshire protect the right to abortion in the state constitution. They want legislators to take action in that way. So it is extremely popular. And I think, when you're voting in support of that, you're demonstrating to granted staters that you trust them to make that decision too, that you can send it to them to take a vote in the ballot box on whether or not to add it. It's extremely popular with folks from all political parties.
Thank you.
Are there any further questions? Okay, seeing none. Thank you very much, Ms. Canada.
Thank you.
Okay. Next, we're going to go, is it Tegan Offit? Did I get that correct?
Tegan, yes.
Okay.
Thank you. Yes, so my name is Tegan Othat. I'm from New Boston, and I'm testifying in opposition of CACR 24. This proposed amendment pretends to secure reproductive freedom for New Hampshire citizens. There is no doubt, however, that it would be used to justify the horrifying crime of abortion without any limitations or qualifications. I think that the majority of New Hampshire citizens, even those who are in favor of abortion under certain circumstances, can probably agree that CACR 24, which would guarantee all women ability to kill their children even up to moments before birth, is far too extreme an amendment to be adopted. I should hope that even those who support abortion in some extreme and difficult cases can realize that these cases are too few to justify an amendment which would give women the option to kill their children for absolutely any reason. At the very least, I think that the majority of New Hampshire citizens agree that there are at least some cases in which abortion should not be allowed, and CACR 24 would leave no room for such cases, and therefore I urge you to oppose it. CACR 24 is based on the idea that a woman's reproductive system, and therefore her choices regarding what to do with those parts of her body, is all her own. This statement on its own is absolutely true. This proposed amendment, however, is surely intended to give women access to abortion in all cases. I do not pretend to understand the incredible difficulty, the incredible hardship and suffering that must accompany a pregnancy that's made difficult by any variety of medical, economic, or any other difficult factors. I do know, however, that murdering an innocent child is just simply never an option, no matter how many other problems it may seem to solve. Philosophy, religion, and science all agree on the fact that an unborn fetus, even from the very first moment of conception, is a human being, completely distinct from his or her mother. This becomes more obvious as the child grows, for example, when he has a heartbeat at 22 days or grows hair by 22 weeks, but the child is no less human even at just 22 minutes or 22 seconds after conception. Thus, while every woman deserves the right to make certain decisions about her reproductive health, this by no means includes the right to kill a person who, though within her body, is absolutely distinct from it. I understand that there are many real New Hampshire women who are dealing with crisis pregnancies, often due to factors totally outside of their control. This just means, though, that we should work to make our state a place where these women, as well as their children, can easily receive the medical, emotional, financial, and any other help that they truly need. Pregnancy help centers and other organizations work to provide this needed assistance. Rather than masking the problem with an overly generalized constitutional amendment that would potentially rob any innocent child of his or her right to live, I think we need to be working instead to increase the real help that our state can offer so that no woman has to face a difficult pregnancy alone and that no woman feels a need to resort to abortion. Every woman dealing with a difficult pregnancy should get the help she needs for both her and her child to thrive. Let's work towards that goal rather than towards a New Hampshire Constitution that will offer utterly indiscriminate access to abortion. To this end, I strongly urge you to oppose CACR 24, and in doing so, to play a role in protecting innocent children, as well as affirming the beauty of motherhood and the dignity of womanhood. Thank you.
Thank you very much for your testimony. Are there any questions from the committee? Okay, seeing none, thank you very much. I have three physicians here, Dr. Melissa Martinez Adorno, Dr. Valerie Danielson, and Dr. Young already testified. Would the two physicians, would you like to come up and testify together, or would you prefer to be separate? Okay, so first we're going to start with Dr. Melissa Martinez Adorno. Thank you. Good afternoon, Doctor.
Good afternoon, Chairwoman Carson and members of the Senate Judiciary Committee. Thank you so much for giving me the opportunity. My name is Melissa Martinez Adorno, and I'm a New Hampshire resident in Bedford. I've been practicing OBGYN for 19 years in the state. I'm currently the co-chair of the Legislative Committee at the New Hampshire Medical Society, and I'm also the legislative chair for the American College of OBGYN. And I'm here today to express my strong support of CACR 24, seeking to amend our state's constitution. Every New Hampshire patient should have access to the full spectrum of comprehensive evidence-based health care, and abortion care is an essential component of comprehensive evidence-based health care. As a physician, I know firsthand that access to this full spectrum of care, including abortion, is essential for patient health, safety, and well-being. Any limitation to medical care that is available to our patients leaves them at risk of both physical and emotional harm and even death. Abortion care is a safe, evidence-based form of health care, and patients should be able to access that health care without the need to have any barriers to that care. Abortion care is intrinsically linked to better patient outcomes, and patients feel the freedom and the support to be able to have the autonomy over their healthcare decisions. Having providers be able to provide the full scope of evidence-based healthcare without barriers is what is recommended by both the American College of OBGYN, the American Medical Association, and is the position that we hold at the New Hampshire Medical Society. CACR 24 would provide our patients, your constituents, with the opportunity to explicitly make clear by voting to amend our state's constitution that their reproductive bodily autonomy, excuse me, and healthcare decisions are not to be decided for them by their government. That should be a decision between the patient and their physician. That healthcare decisions are just to be decided in consultation with their expert medical providers, loved ones if they so choose, in doctors' offices, and should not be predetermined by their elected officials in legislative committee rooms. As we continue to see around the country, particularly since the fall of Roe, it is imperative that the state takes measures to protect our citizenry from further dismantling the ability to provide reproductive health care to our patients. For these reasons, I urge the Senate Judiciary Committee to recommend an ought to pass for CACR 24, as I said before, supported by the New Hampshire Medical Society. And thank you for your time and consideration.
Thank you very much for your testimony. Are there any questions? Senator Whitley?
Thank you, Madam Chair, and thank you for taking my question. I have watched in horror around the country as, women have gone to ERs in sepsis because physicians are terrified to provide them with reproductive care. Do you have similar concerns that something like that could happen in New Hampshire?
I mean, I think that the care of any human is incredibly complicated. And to have to be worried about the legislature when I'm in a room with a patient is something that shouldn't be, regardless of the medical condition. And so, unfortunately, with the fall of Roe, being able to support the protection that reproductive health care isn't carved out as the one field of medicine where the legislature can actually be in that room with me is what I'm here to support.
Are there any further questions? Senator Gannon?
So you're well aware of the laws we passed a couple of years ago. Are they not far enough for you at 24 weeks? Fetal, fatal, and all the other exceptions. Was that good for you at the time?
Yeah.
Sort of mirrored Roe. Was that far enough? This seems to take it further.
I don't think, thank you for your question. I don't think that the legislature should be in the room making incredibly difficult decisions. Many of these decisions are incredibly tragic for all involved, sadly, including us. And we're also human beings. And to have to worry about the legislature's decision, if you're in a life and death decision, do you want to look at your colleague on the left or on the right and have them in the room with you? And that's what I'm saying, is that we should really have doctors and patients making decisions, however difficult they are, however complicated they are, that are difficult to understand in this room, that should be a decision between me and my patient.
Thank you.
I just have a quick question. Thank you, first of all, for being here this afternoon. I appreciate you coming. We had previous testimony that I agree with, and it was from Dr. Young when he said this issue has become politicized. And it's unfortunate, but that's where we are.
Correct.
The Supreme Court punted it back to the states and said, you decide. That's why we're all here in this room today, and that's why we are having this discussion. Senator Gannon had talked about the 24-week, what we have here in New Hampshire, which I think is reasonable. 24 weeks, no question asked. You can do whatever you like. That's between you and your doctor. Oh, and by the way, if it's beyond that, if there's the health and safety of the mother, some sort of fatal fetal anomaly, again, that is between you as a physician and your patient. You as a physician gets to make that determination based upon your medical knowledge that this is a health risk, a huge health risk for the mother, or there is some sort of fatal fetal anomaly where there's no compatibility with life. But do we really need to go beyond that? And that's my question to you, because I thought when we did this, we tried to cover all of our bases to ensure that the women of our state that found themselves pregnant and did not want to carry that child for whatever reasons, no questions asked. You don't have to quantify any reason. You can go and you can get this done. But we're just saying in the last 7th, 8th, and 9th month that this infant is viable and that an abortion should only happen at that point under certain circumstances. Do you believe we need to allow abortion right up to the day of birth?
I think what I believe is that any decision that's medical should be made between the patient and their provider, that the legislature has no role, that the complications that medicine is incredibly complicated, and it's impossible in this room to cover the full scope of all the potential possibilities of what can happen to a woman, to a baby, and everywhere in between. All I'm saying is that we should be protecting that decision should be made by the doctor and their patient. When you start putting numbers on things, you're excluding the possibilities of things that we haven't thought about. And you're right, we are saying life of the mother, fatal anomaly, but who decides what that is? And so fundamentally, what I'm saying is that it's difficult and complicated to take care of patients. And the decision should be made between the doctor and the physician. And we see as Roe fell that we're starting to carve out reproductive health care. And so this, to me, is a way of supporting us in our ability to have that patient-doctor relationship preserved.
I don't mean to, I'm not trying to be argumentative or question,
No, of
but
course.
you're a medical professional.
Yes, sir.
And I would think, my personal opinion again, that as a medical professional, you have gone through years of schooling
Right.
and training, that you as a medical professional would be in a position to help the patient make a
Yes.
decision that has nothing to do with any of us.
Right.
We are not in the room. We've just said fetal anomalies that are incompatible with life, or if a woman who is 8 months pregnant comes to you, and they're a patient, and that fetus has died in the womb, you as a medical professional are going to make a decision about what is going to be in the best interest of your patient. We are not in that room. The government, and when I say we, the government, you are as a medical professional. We tried very hard to stay out of that. That is why we are relying on you as a medical professional to make that decision. So you're interpreting that as something very different?
I'm not sure that I understand your question, but I think we're actually on the same page. I do agree that the doctor and the patient should be making those decisions. Full stop.
Okay, thank you. I appreciate it. Senator Whitley.
Thank you, Madam Chair, and thank you for taking a follow-up question. Senator Carson is sort of jogging my brain a little bit. I mean, I think what we hear, this sort of pushback is, we want women to, have abortions right up to birth, but I think that's a very dangerous rhetoric, because what I understand, and I would like you to tell me whether that's true or not, is what I understand is that is a very dangerous and false rhetoric. Women are not asking for that. That is saying that women are making these horrific choices about their pregnancies. Senator Perkins Coca spoke very eloquently when she herself was 24 weeks pregnant, saying, I know what's best for my body. I know what's best. You don't trust me beyond 24 weeks. You trust me before, you don't trust me after. So are women actually asking for these abortions, so-called right up to birth, or is this just dangerous rhetoric?
Yeah, I mean, I think the data shows that less than 1% of all abortions are actually after 24 weeks, and even a smaller percentage of that 1% are in the third trimester. I think the human condition is complicated. I definitely think that there's a rhetoric and a story being told. I don't really want to get into any of those details. I just know that for me, the physician, I don't want the legislature in the room with me and my patient. Every patient has their own medical conditions and their own life that they have to take into account. It's difficult for providers when we're worried about whether we're going to be prosecuted to take care of our patients. That consideration shouldn't be in the room.
Are there any further questions? Seeing none. Thank you very much,
Thank
Doctor,
you.
for your time this
Yes.
afternoon. The chair will call Dr. Valerie Danielson.
Chairwoman Carson and members of the Senate Judiciary Committee. My name is Valerie Danielson. I am a New Hampshire resident and a family medicine physician here in New Hampshire. I'm here today in strong support of CACR 24 relative to reproductive freedom. As a family physician, I have the unique and special opportunity to care for generations of families, from grandmothers, mothers, to children and grandchildren. And during my time practicing, I have been the healthcare provider for many generations of patients who have required access to reproductive health care, specifically abortion care. Abortion care is a provision of health care that I have never taken lightly as a provider, nor of my patients. One patient story that I recall most vividly, a story that I feel important to share with you all today, is about a patient who learned that well past 20 weeks into pregnancy that her fetus had a genetic condition called trisomy 18. Trisomy 18 is a devastating condition that is often not discovered until later in pregnancy, and it's a condition in which only 50% of babies who are carried to term will be born alive. About 90 to 95% of babies do not survive beyond the first year, and many only survive a few days. This diagnosis was heartbreaking for the family, as well as for me as a provider caring for that patient. This diagnosis led my patient, after consultation and support from me as her healthcare provider and her loved ones, to make one of the most difficult healthcare decisions, terminating a pregnancy. A healthcare decision that thankfully my patient was able to make the way our state laws are currently written, and I wanted to emphasize currently. Since the fall of Roe, the nation, including New Hampshire, has witnessed just how rapidly women can and have had their reproductive rights and freedoms severely stripped or completely eroded in many states. In an instant, based on the political trends of legislatures around the country. CACR 24 would rightfully return the ability for the patients of the state to make their own reproductive health care decisions, free from government intrusion and the endless introduction of legislation seeking to alter or repeal abortion care access in New Hampshire. For these reasons, I ask the Senate Judiciary Committee to recommend an ought to pass on CACR 24, as it is essential that all persons have the right to make their own reproductive health care decisions. Thank you for your time and consideration of my testimony.
Thank you very much, Doctor, for your testimony. Senator Gannon has a question.
Yeah, just a quick question in your testimony.
Yeah.
You put Roe, the nation, including New Hampshire, has witnessed, the rapid fall of reproductive rights. I don't know that we've stripped any rights away from women under the New Hampshire laws. The 24 weeks, Senator Carson's explained there, the other exceptions. So to me, we have the same as before Roe. So I don't see any stripping in New Hampshire. Is there something I'm missing?
Thank you for your question, and thank you for allowing me to clarify. I think that I would agree with you. I don't, it probably was misspoken on my behalf.
Thank you.
Okay, Senator Whitley.
Thank you. Are you aware that when the 24-week ban actually passed in state law, there wasn't an exception for a fatal fetal anomaly? Are you aware that we actually had to add that going forward?
I was aware of that, yes.
And you're aware that there were some patients that were truly impacted by that?
Yes.
And are you aware that when that abortion ban was first passed, there was a mandatory ultrasound for every single abortion, including women very early in pregnancy, that it was not medically indicated to have that ultrasound?
I was aware of that.
And are you aware that women were dramatically impacted by that truly invasive and medically unnecessary procedure?
Yes, I can imagine it would be very devastating for a patient and their family.
Okay. Are there any further questions? Seeing none, thank you very much, Doctor.
Thank you.
Okay, the chair is going to call Bob Dunn.
Thank you, Madam Chair, members of the committee. Happy New Year. It's good to be back in these familiar environs. It seems like just yesterday that we left. I'm Bob Dunn, the Director of Public Policy for the Roman Catholic Diocese of Manchester, and I'm here today on behalf of Bishop Peter Labashi to register our opposition to CACR 24 and also all of the other bills that are going to be considered today. I've signed in opposition to those, and I have written testimony, but I'll confine my remarks just to this one today because they cover all of them. And I really just want to make one brief point. I think in this incredibly divisive question that probably most of the people in this room today would agree that the principles of human dignity and solidarity are beset by many challenges in today's world. And so I want to ask the committee, as you deliberate over this constitutional amendment, would the work of building up human dignity and solidarity be advanced by the enactment of a constitutional amendment that declares, in effect, that a certain category of human beings is designated as being disposable? As I know I've said to this committee before on a number of occasions, I think that the human dignity of the young child in the womb, the young human being in the womb, is inseparable from the human dignity of the young human being at the border, or the young human being who needs food or shelter or health care. If we start asking society to designate certain ones of us as expendable, we can't be surprised if society begins to treat certain ones of us as expendable. And so we ask you to vote ITL on CACR 24. Thank you.
Thank you very much, Mr. Dunn. Are there any questions from the committee? Thank you very much. The chair will call Michael Lewis. Good afternoon, Mr. Lewis.
Good afternoon, Madam Chairman, members of the committee, neighbors. We're a difficult topic. We're all in this together. I've got some written testimony. Provide copies over here.
Thank you.
Really just want to point out three things. I'm really just a member of the public, some guy with a tie is very interested in the topic. And one, we're kind of inconsistent with ourselves in New Hampshire. The second, about how popular things that the majority has kind of gotten wrong in the past. And then third, I think we ought to think about the risk of the decision. I'm here to oppose adding this to the Constitution because I think we're really not ready for that. We're not sorted out. So we allow abortion for 24 weeks, and yet in New Hampshire, quoting from the House bill text on 625 FN from last year, New Hampshire has historically seen the fetus as a separate entity from the mother with distinct legal interest, and then from the time of conception. So recognizing in our own law, essentially, that the fetus exists and from the moment of conception with distinct legal interests. So you have to ask yourself, what are those legal interests of the fetus with CA-CR 24? What would your interest be if you were the fetus? You know, kind of what's reasonable, right? And finally, you know, if a pregnant woman is shot in the street and she and the fetus die, 2 murder charges are on the table. And if the woman survives and the fetus doesn't, there's another murder charge. So we seem to recognize that there was a human life there up to the moment of death. Kind of makes sense that we should recognize that before it's dead. And so I leave you with that, and I want to move on to, you know, so what's the legislature to do? It's popular. The majority supports it. But the majorities get a lot of things wrong. Let's just take a little step back through history, starting with the most recent. Get the shot, you won't get the virus. OxyContin is safe, not addictive. Smoking does not cause cancer. Asbestos is safe. I mean, just those last 3, we've put millions of lives away, dead people, from getting those 3 wrong. The asbestos one's a personal favorite because in 1969, I got to go to the quarry as a school kid on a school trip. I don't think the hazmat suit had been invented. Kids walking around, mouths agape, you get to run your fingers through the tailings and bring a sample home, and you can peel that white stuff off the rock. So proud of that. Left it in my bedroom, slept with it for months, years. So we have to have the humility that we get big things wrong. We hadn't sorted out, does the earth move around the sun or the sun around the earth? Someone had figured out in the 3rd century BC, we hung on to the wrong view for 1700 years because we just looked at some of the facts. You can step outside, see the sun come up over that horizon and set on this one. It looks like I'm stationary. Just the opposite turned out to be true. We're on a moving ball. We're doing all the moving as we come into sight of the sun or not. So depending on whether you look at some facts or all the facts, you get to a very different place. And then finally, probably horribly tragically, slavery was popular. There were 8 slave states and 5 free states at the time of our Constitution. All right? And there were slaves in the free states. So we get big things wrong. It seems to be part of our human condition. So I would encourage everyone to kind of look at the risk involved. So let's say, we want to support abortion, but we're wrong about it, and we should be respecting those lives. That's 1 million dead a year, about 4,000 in New Hampshire, just using the ratio of our populations. So that's the risk. If we're wrong about it, we're killing 1 million lives a year that should have been supported and respected. On the flip side, of those 1 million lives, of the 4,000 in New Hampshire, we'd get, if abortion's okay, but we don't allow it, then we're raising more children. It'd be about 740,000 more children. In the whole US, about 3,000 in New Hampshire. And that's not a challenge-free. But all of the things that come with that are workable and mitigatable. There's no way to get the lives back. So I encourage you to think about the risk and things that we could work on if we're just raising more children, if we're not happy with the mortality rate of pregnant women, which I'm not. We rank like between 30 and 60 in the world. We ought to have the best rate. We have the lowest, most survivable experience for women in pregnancy of any nation on earth. It's a tragedy that we don't. We should be working on that anyway. We should be working on making adoption better. We should be working on, helping deadbeat dads to step up. All of those things are things we should be working on anyway. So again, we're inconsistent. Majorities get big things wrong all the time. So let's think about the risk and make a decision that errs on the side of the least harm, which be to oppose putting this in our Constitution. Thank you for your time.
Thank you very much for your testimony, Mr. Lewis. Are there any questions from the committee? Seeing none, thank you.
Thank you.
The chair
Happy New
will
Year.
call Devin Quinn. Good afternoon, Ms. Quinn.
Good afternoon, Madam Chair and members of the committee. My name is Devin Quinn. I'm the Director of Policy at the New Hampshire Women's Foundation, where we invest in equality and opportunity for Granite State women and girls through research, education, advocacy, and grant making. And we are proud to support CACR 24 because access to the full range of reproductive health care, including abortion, is crucial to women's health and economic security and has long-term impacts on women and their families. New Hampshire is the only state in New England that has not protected the right to abortion in state law, despite a long history of New Hampshire women from across the political spectrum fighting for decades for their rights to reproductive freedom. It is time to allow New Hampshire voters to decide if there should be a clear and affirming right to bodily autonomy in the state's constitution. Not only is the choice to end a pregnancy a right, but it is for some a means to economic prosperity, safety, and the ability to flee violence, the opportunity to pursue dreams and develop thriving communities. In New Hampshire, women are more likely than men to live in poverty with a gender wage gap that increases by race, ethnicity, and county, and they are more likely to have been impacted by interpersonal or sexual violence. These indicators of well-being are significantly impacted by the ability to make reproductive decisions, including abortion for oneself. we must protect the right to abortion to continue support women's autonomy, health, wellness, economic security, and ability to support thriving families and communities in New Hampshire. And that is why we support CACR 24.
Thank you very much for your testimony, Ms. Quinn. Are there any questions from the committee? Seeing none, thank you. The chair will call Beth Scare. Good afternoon, Ms. Square.
Yes, hi, I'm Beth Scare. I'm a mom from Nashua, and I'm here to testify in opposition to CACR 24. The first thing that struck me is, why is there no age limit in this bill? Could it be used to sterilize a girl or a boy that are way too young to consent? Also, it looks like it makes it legal to kill a baby up to birth right up until the moment of birth, using gruesome means like partial birth abortion, where the baby's head is delivered, the skull is crushed, and the brains are sucked out before the rest of the baby is delivered dead. And it would also looks to me like it would allow 12-year-old girls to get abortions without parents being notified, and which would allow a pedophile or a sex trafficker to impregnate a girl over and over and hide his crime by taking her for abortions. And with so many immigrants flooding the country, I expect that we will be seeing an explosion of sex trafficking of these immigrant teen girls. And I'm afraid the lobbyists for the abortion businesses here are counting on that kind of business to, increase their profits. So look at their motives for why they're here pushing for this. Please vote ITL on CACR 24 to protect moms and babies.
Thank you very much for your testimony, Ms. Scar. Are there any questions from the committee? Seeing none, thank you. The chair will call Ruby Furbish.
Good afternoon, and thank you for your time today. My name is Ruby Furbish. I'm a student at Gordon College in Massachusetts, but I grew up and reside here in New Hampshire. I'm speaking on behalf of Students for Life Action today, along with their sister organization, Students for Life of America. We're the nation's largest pro-life youth organization, working to end abortion, the human rights issue of our day. And we have 9 student groups right here in New Hampshire. I'm here as a woman, a nursing student, and a New Hampshire voter to express my concern and strong opposition to CACR 24. Live free or die is the motto of this proud state. We take the notion of individual rights and freedoms extremely seriously, but we need to stop and ask if the barbaric practice of unlimited abortion is the kind of so-called freedom that we should desire. The proposed language of the constitutional amendment before you today states that an individual's right to personal reproductive autonomy is central to the liberty and dignity to determine one's own life course and shall not be denied or infringed. But what of the liberty and dignity of the preborn life? Currently in New Hampshire, abortion is accessible before 24 weeks with protections in place for the mother's health. Most parents at that time have already chosen a name for their child, know its gender, and have seen their baby on an ultrasound. A baby with fully developed arms, legs, facial features, and major organs like its lungs, brain, and heart, which is beating rapidly as it develops and has been from 6 weeks. And thanks to modern technology, babies can now survive outside of the womb in the NICU from 24 weeks on. So what about the infringements upon that living human's autonomy? A January 2023 poll by YouGov Research showed that more people now believe abortion should be illegal, at 23% in 2023 compared to 9% in 2022. When they are asked if laws should limit abortion, 67% said yes, and 68% of pro-choice Americans agreed that it's wrong to abort a child up till 9 months. What women need are real, life-saving, and life-giving resources. There are many pregnancy resource centers in our state that are ready to walk alongside women and support them through pregnancy and early parenthood, no matter what their circumstances are. They offer services like ultrasounds, parenting classes, after-birth counseling, and more, and they are ready to help at any stage. These are the services that we should be focusing on. But the constitutional amendment we are talking about is not designed to help women, but to increase the bottom line of pro-abortionists by removing impediments to late-term abortions. Can we imagine becoming a state where 7-pound babies that are fully capable of surviving outside of the womb are under the threat of being aborted for any or no reason? That's not freedom. Women deserve better than the violence of abortion, and no woman's life is made more prosperous by the death of her child. I'm asking you to reject late-term abortion, and I strongly urge you to oppose CACR 24. Thank you.
Thank you very much for your testimony, Ms. Furbish. Are there any questions from the committee? Seeing none, thank you.
Thank you.
Okay, the chair will call Courtney Reed. I think it's Reed. Did I get that? Is it Reed?
Yeah.
Okay.
Thank you so much for your time. My name is Courtney Reed. I serve as policy advocate at the ACLU of New Hampshire, and I wanted to provide a brief statement of support for CACR 24. As others have said, a constitutional amendment is one of the most effective tools that New Hampshire can use to ensure reproductive rights for everyone in our state. And after the overturn of Roe v. Wade, we no longer have federal protections, and it's up to states to ensure these rights for their citizens. We've already seen constitutional amendments successfully passed by the will of voters in states like California, Michigan, Ohio, and our neighboring state of Vermont. And this CACR would allow Granite Staters the same opportunity to choose to protect that right. As I said, there are no other state-level protections in place in New Hampshire, and this leaves the state at risk for future attacks on abortion, which are directly related with negative health outcomes. And with these federal protections gone, passing legislation like this is all the more important. I also wanted to cite that health risks from continued pregnancy are also linked to difficulties escaping poverty or derailing one's education, career, and life plans. And that is all the more important for people to have the autonomy and dignity to be able to choose what's best for them and their life course. We already know that this is something that's popular among Granite State voters, so we should give them the opportunity to vote on this. And you should, I recommend that you OTP the bill. Thank you.
Thank you very much for your testimony, Ms. Reed. Are there any questions from the committee? Seeing none, thank you.
Thank you.
Okay, the chair will call, let's see here, Heather Martin.
Good afternoon, everybody.
Good afternoon.
Thank you for giving me the opportunity to speak. My name is Heather Martin. I am a tireless maternal mental health advocate here in New Hampshire and beyond. I work for Dartmouth Health Children's in Manchester, where I help support our mothers by doing maternal mental health screenings in our office and follow-ups to make sure our mothers are getting the support they need during the postpartum period. I am also a postpartum support coordinator here in our state. I take phone calls from moms and family members looking for mental health support and connections. I connect them with groups, providers, and other connections in the state. We are already strained with the lack of access of mental health providers in our state, and specifically a lack of perinatal mental health providers. Perinatal meaning during pregnancy and postpartum. And for those of you that don't already know, we are in a maternal mental health crisis, with maternal mental health conditions, suicide and overdose being the #1 cause of pregnancy-related deaths in our country. Without protection for abortion access, this number will rise. Unintended pregnancies have shown a significantly higher risk for perinatal depression, anxiety, and can have negative impacts not only for the mother, but the child as well. And studies have shown that mothers suffering from a perinatal mood disorder show that their child is at increased risk for cognitive, emotional delays, as well as risk for behavioral problems later in life. We know that. They've done many studies more recently. And last year, our state received an F grade from the Policy for Maternal Mental Health study due to the lack of consistent screening, lack of perinatal mental health certified providers, and our maternal mortality rate here in New Hampshire. We have been working very hard to better that grade and to figure out innovative solutions to help support our mothers, but we are failing. We have a lot of work to do, and I am hopeful that that grade will get better, but not without the protection of abortion access. I am hopeful that you will support CACR 24 so the #1 issue affecting our moms here in our state doesn't worsen. Thank you.
Thank you very much for your testimony. Are there any questions from the committee?
Thank you.
Seeing none, thank you.
Thank you.
Okay, the chair is going to call Jake Berry.
Good afternoon, Madam Chair, honorable members of the committee. My name is Jake Berry. I'm the Vice President of Policy at New Futures. As many of you know, New Futures is a nonpartisan, nonprofit health policy and advocacy organization. We've been working for decades to increase access to quality, affordable health care and to improve health equity in our state. I don't want to repeat too much of what's been said, but I do want to stress New Future's strong support for CACR 24 and the other abortion bills you're going to hear this afternoon. Reproductive care, including abortion, is a critical part of overall health care, and access to abortion has direct ties to the physical, social, and economic health of our state. Data shows that women who are denied access to abortion experience more severe and life-threatening medical complications like eclampsia, postpartum hemorrhage, as well as chronic migraines, joint pain, and gestational hypertension. Women who can't access abortion are less likely to have the money they need to cover food, housing, and other basic needs. And children born as a result of abortion denial are more likely to live below the federal poverty level. Simply put, families that have access to abortion are healthier, happier, and face a brighter future. With that in mind, we ask you to support CACR 24 as well as the other bills coming before you this afternoon. Thank you for your time, and I'm happy to take questions.
Thank you very much for your testimony, Mr. Berry. Are there any questions from the committee? Seeing none, thank you.
Thank you.
The chair is going to call Michael, it looks like Strand.
you doing?
Good afternoon, Mr. Strand.
Appreciate your time this afternoon. My name is Michael Strand. I'm a Bedford resident and a town councilor, testifying in favor of this bill. For me, this is personal. Let me tell you the story of a pregnancy that became impossible. When my daughter's premature birth required emergency surgery, I've never prayed harder in my life. I thought if I were lucky, I might get one of them out of it. One person, mother or daughter, might live. And I was lucky. But if push came to shove and God forbid my daughter wasn't going to make it, we would have had a choice. Her mom had a choice whether to live or die. Even before that, when we faced an unplanned pregnancy, her mom had a choice. I was grateful that she let me play a role in that decision, as if I hadn't done enough, but it wasn't up to me. With regard to the choice you have before you, whether you will decide whether we should constitutionally guarantee the rights of women and girls to decide the course of their own pregnancies, especially in the worst of life-threatening situations that we would not wish upon any one of our fellow citizens or human beings, I think we should clarify several facts. The truth is, no one chooses elective abortions in the second or third trimesters, unless something has gone seriously wrong, or a minor girl withheld preventative health care has had the unthinkable happen to her. The truth is, judicial prohibitions regulating timelines on abortion and reproductive health care are a gateway government overstep that undermine basic, constitutionally guaranteed civil and existential rights for women. These regulations are about politics, not people, not babies, and certainly not health care. The truth is, these same prohibitions weaken prenatal emergency health care, scare doctors from doing their jobs in the hardest and worst of situations, when permission from judges or politicians is not a luxury the government has any right to require. The truth is, regardless of politicians legislating and politicizing the bodies and rights of real human beings and women, I say to every man on this committee, it's not up to us. In New Hampshire, we've always been both drawn towards the light and led with it. New Hampshire has always been on the front lines of freedom, the Revolutionary War, the abolition movement, the advent of public education in America, and modern healthcare. Our nation looks to New Hampshire for firsts. However, lately, we are not sure what we're looking for. So I would advise, when you make your choice as elected leaders, you ensure it does not require you to restrict the personal private healthcare decisions or basic God-given rights of your female constituents, or else as voters, we will be sure to exercise ours. Have a good afternoon.
Thank you very much for your testimony, Mr. Strand. Are there any questions from the committee? Okay, seeing none, thank you. Next, the chair is going to call Phyllis Woods.
Thank you, Chairman Carson and members of the committee. In the interest of time, I'm not going to go through the testimony that I prepared, but I would like to ask you a question. Why are we working on expanding the availability and the right and the insurance for abortion in 2024? Back when Roe v. Wade was passed, we were assured that abortion was going to be legal, safe, and rare. Over 60 million abortions later, that certainly has not proved to be the case. Then Planned Parenthood said, we'll go into the schools and hand out condoms. We'll make sure they have birth control pills and IUDs and every other available means to prevent conception and to limit the necessity for abortions. Why do we have such a problem today that we're talking about expanding different means and different ways to ensure the right to abortion? Have we failed in our education? We brought sex education into schools at a very early age. Are we not educating our young men and women that the natural consequence of sexual activity, the natural consequence is conception. We have a number of questions here where people have been sold a variety of myths that this is a choice for women to be able to terminate a living child in their womb. They were told in their sex education classes that this was not a real human being or a fully developed person, that it was their property and their right, similar to what we were told about slaves by slave owners at the time. I'm asking you to reject the whole concept of putting into our Constitution or expanding by any of these bills people's so-called right to terminate the most vulnerable in our society. A nation is going to be judged by how they treat the most vulnerable among us, and certainly a child within the womb is the most vulnerable among us. Thank you for your time.
Thank you very much for your testimony, Ms. Woods. Are there any questions from the committee? Seeing none, thank you. The chair will call, and I think it's Marina Kirsch. Good afternoon, Ms. Kirsch.
Good afternoon. Good afternoon, members of the committee. My name is Marina Kirsch. I live in Kensington, New Hampshire, and I am opposed to CACR 24 because I believe that no one should have the right to deprive an emerging human being of life. Sanctity of life is not only a religious belief, but a moral and ethical conviction for millions or even billions of people across the world. It cannot be erased from human consciousness, but it is all too often easily erased and rationalized away for the sake of expediency. My personal experience at a young age dictates my current pro-life stance. And I have to say that about 10 years ago, I left the Democratic Party, and the reason for that was largely the pro-life versus abortion issue. And my understanding is that about 33% of Democrats across this country have relatively strong pro-life convictions. At age 17, before abortion was legal, I was pregnant out of wedlock. Had it been legal and left to my own devices, I might have decided to take the expedient course. I had misgivings about my future. To put it short, I was scared. Instead, it wasn't legal and it was out of my hands. My parents objected strongly, but they were also very, very supportive of me. I surrendered my daughter for adoption, and later I decided I would have no other children. More than 2 decades later, my daughter, Crystal, contacted me. I can actually give a face and a name to this issue. When I met her and her husband, they had 2 daughters, Cassie and Katie. And by this time, Cassie has 2 children, Logan and Luna. They are already 6 and 4 years old. And they have become the face, the name, and the beating heart of my pro-life conviction. A decision for life always leads to greater life. To the women here today, whatever our personal decisions have been in the past, and believe me, I can identify, we can reclaim and stand up for our unique position as the bearers and defenders of life. It's a position that is so important, so fundamental, but yet often devalued because it cannot be monetized. Nothing devalues it more than the practice of abortion. Abortion is not health care. It is not a fundamental right. It also clearly violates ethical and spiritual standards, as well as the U.S. Constitution that states, all men are endowed by their Creator with certain unalienable rights. Among these are life, and I have that in all caps. Please do not enshrine abortion in the Constitution of our granite state. Please follow your conscience and vote no on CACR 24. Thank you.
Thank you very much for your testimony, Ms. Kirsch. Are there any questions for Ms. Kirsch? Seeing none, thank you. Okay, I have gone through the list of the individuals who have signed up, who wanted to speak. Are there any members of the public that would like to address the committee? There was someone who raised their hand. Ma'am, if you would come forward, make sure to speak your name very clearly for the record. Oh, okay, sorry. I didn't have this last paper. There's a few people who would like to speak, so I'm going to ask you please to don't read anything. Please just kind of paraphrase what you have for us.
Chairwoman Carson, members of the Senate Judiciary Committee. My name is Dr. Cynthia Rasmussen, and I am a New Hampshire resident. I'm a retired obstetrician gynecologist, having practiced for 32 years, most of them in New Hampshire. I'm here today to express my support of CACR 24. Reproductive health care is a complex and nuanced field which requires expert management. There are so many ways that a pregnancy can end up in crisis, and access to medically appropriate intervention is essential. Blood pressure emergencies happen, dangerous diabetes complications happen, cancer during pregnancy happens, imperfect chromosomes happen, infections of all kind happen, membranes rupture prematurely, fetuses die in the uterus early and late, and bleeding, nothing bleeds like a pregnant uterus. Situations like these require timely and skilled intervention to preserve life and fertility. Unintended and undesired pregnancies are also an unavoidable part of the reproductive spectrum. Rape happens, incest happens, contraceptive failures happen. The point is, the challenges of reproduction are too complex for rigid political restrictions, and forced continuation of pregnancy is often at odds with the medical standard of care. In addition, one of the foundations of medical ethics is honoring the patient's bodily autonomy, her right to make decisions for her own life and body. This is explicitly violated by legislative bans and restrictions. In this country, it's against the law to practice medicine without training or a license, and it's malpractice to withhold or delay care in a fashion which causes harm to a patient. Unless, of course, the patient is having an obstetrical issue in a state with restrictions on reproductive health care. In my career, I have presided over terrifying obstetrical emergencies as my own shoes fill with someone else's blood. And the reality is that my training, judgment, and experience may be all that stands between the patient and disaster. It is unconscionable that someone with no medical training should require, under the threat of fine or imprisonment, the withholding of appropriate and life-saving medical treatment because the patient is pregnant. And it is unacceptable to require a medical provider to choose between violating medical ethics or committing malpractice and following the law. These most intimate and complex of healthcare decisions belong in the privacy of the exam room between the affected individual and their medical caregivers. No person in medical crisis should have to have their personal tragedy played out in the courts or the news or in the cruel and invasive free-for-all of public opinion. I have lived through the pre-Roe era, and I am all too familiar with its horrors and its tragedies. In the post-Dobbs era, we are endangering women again. It is critical that we support these bills which protect medical decision-making against inappropriate political interference for ourselves, our daughters, and our granddaughters. For these reasons, I urge the Senate Judiciary Committee to recommend ought to pass on CACR 24.
Thank you very much for your testimony. Are there any questions from the committee? Okay. Doctor, I have a question. We've listened to you and you gave us a list of potential emergencies that can happen to a woman during pregnancy. Are you telling us that you as a physician can't do anything about it?
No, I'm suggesting that that the management of those conditions requires training and experience, and that that you're going to have the best outcome for women and their fetuses if medical providers are not afraid of being fined or imprisoned for doing their jobs.
Okay, I'm sorry, but I'm just trying to understand your position here. So are you more concerned about the abortion aspect, or are you more concerned about the fact that you feel that this ties, the existing laws we have ties a physician's hands because there are criminal penalties involved?
Yes, that is, I mean, there are many, many facets to this very complex issue. But I think that the criminalization of healthcare by people who are not trained in medicine creates a situation where everybody loses.
Okay, thank you. Thank you very much for your testimony. Okay, next we are going to hear from Matthew Rhodes. I think it's Matthew. Are they outside? Oh. Okay. Next, we're going to go to Carlos Cardona. No one's out there. Okay. Then we're going to go to Jason Hennessy. Is there Mr. Hennessy in here? There we go. Okay.
Thank you, Madam Chair.
Thank you.
Is right on. Oh, thank you, Madam Chairwoman, honorable members of the committee. My name is Jason Hennessy. I'm here to represent New Hampshire Right to Life, New Hampshire's largest pro-life organization that's dedicated to the issue. There are many thousands and hundred thousands of us who would vehemently oppose this legislation, primarily because it's extreme. This would legalize abortion till birth. 8-9-month viable children would lose their protection that they currently enjoy under the Fetal Life Protection Act. This disagrees with about 90% of Americans and at least about 70% of New Hampshire views from the studies I've seen. Keep in mind that the Fetal Life Protection Act only protects viable children after about 6 months. If we look at statistics from other states on late-term abortion, or Arizona or Florida, you can see that about roughly half of late-term abortions are elective, have nothing to do with medical reasons or anything like that. There aren't a lot of these statistics because there just aren't that many of these abortions. About 1% is what I've seen and agrees with what I've heard here. Also, CACR 24 does nothing to empower women. In fact, it could do things to harm women. For example, if the state can constitutionally not protect women from abortion, what's to stop back alley abortions from coming back? I also want to bring up Brooke Fisk. Brooke had his on again, off again relationship for over 3 years, found herself pregnant. And when she went to visit her ex-boyfriend and asked if he's going to help, he actually slipped her misoprostol, which caused her to miscarry. Under this legislation in CACR 24, could a judge interpret this as a defense, that everybody has a right to abortion? This is horrific to even consider. So I want to ask you, what help does this actually offer to empower women if they want to choose life? The CACR 24 offers nothing in that regard. And with that, I thank you for your attention.
Thank you very much for your testimony. Are there any questions for the committee? Senator Abbas.
Thank you, Madam Chair. If I understood your testimony correctly, you said that basically you didn't say that this would strike down the Fetal Life Protection Act. Is that correct?
That's my understanding from reading the proposal.
May I ask a follow-up?
Yes.
What are you basing that on, any like legal conclusion, or what are you basing that opinion on?
So if I can read the text for you. The text is that an individual's right to personal reproductive autonomy is central to the liberty and dignity to determine one's own life course and shall not be denied or infringed. I mean, as a non-lawyer, would seem pretty clear to me that the Fetal Life Protection Act denies or infringes the right to take the life of children after about 6 months.
Thank you.
Follow up? Are you all set? Okay. Senator Whitley?
Thank you, Madam Chair. Thank you for taking my question. Are you aware that this is just a CACR?
Yes, ma'am, the constitutional amendment.
Right. No, actually, it's not a constitutional amendment. This is a concurrent resolution proposing a constitutional amendment. So that means we are not amending the Constitution by passing this resolution. We are sending this to the voters. So by passing the CACR, we are not overturning anything. We are sending it to the voters. Are you aware of that?
Thank you, Madam. My understanding is that by voting to approve this, you are advancing the legislation or the constitutional amendment forward. That would be out of line with the vast majority of the citizens, in my opinion.
Thank you very much. Thank you very much for your testimony, Mr. Hennessy.
Thank you, Madam
Okay,
Chair.
seeing that no other individuals have come forward, we're going to go ahead and close the public hearing on CACR 24, and the committee is going to be in recess for 10 minutes. I know. Again, we're going to open the public hearing on Article 575 and recognize the current sponsor. So we're going to roll call. Good afternoon, Chancellor.
Good afternoon again. Thank you, Chairwoman Carson. Good afternoon. My name is Deborah Altschuler. I represent Senate District 24, which includes the towns of Exeter, Greenland, Hampton, Hampton Falls, Northampton, Rye, and Stratham. This proposed bill, Senate Bill 575, addresses crucial aspects of legal protection and cooperation in the realm of reproductive health care, ensuring the constitutional rights of individuals are respected and upheld. The bill comprises several key provisions aimed at safeguarding the rights of those involved in reproductive health care services. I will highlight 4 of the major components of this proposal. Number 1, prohibition against extradition for legally protected healthcare activity. The first section of this bill introduces a prohibition against extraditing individuals for legally protected healthcare activity performed in New Hampshire or any other state where reproductive health care services were provided in accordance with laws of that state. This ensures that individuals cannot be held criminally liable or extradited for engaging in protected reproductive health care activities, reinforcing the principle that these activities are legal and should be treated as such. Number 2, prohibitions on cooperation with out-of-state investigations. The second and third sections of this bill establish strict prohibitions against government officials or law enforcement agencies cooperating with out-of-state investigations into legally protected healthcare activity without court-issued subpoenas or warrants. This protects the privacy and confidentiality of reproductive healthcare services and prevents any unwarranted interference or disclosure to external entities. Number 3, protection against adverse actions by medical boards. The 4th and 5th sections of this bill prohibit adverse actions or discipline by the Board of Medicine, Board of Registered Nursing, or Pharmacy Board based on legally protected healthcare activity. This ensures that individuals licensed under those boards are not penalized for engaging in legally protected reproductive healthcare activities, even if such activities have resulted in convictions or adverse actions in other states. And 4, confidentiality of reproductive healthcare information. The 10th section in this bill introduces a prohibition against healthcare providers or other entities in New Hampshire from sharing confidential communications or information regarding reproductive healthcare services with out-of-state agencies or individuals without a valid court-issued warrant. This reinforces the privacy rights of patients and protects sensitive information from being disclosed without proper legal authorization. Senate Bill 575 is a comprehensive and necessary piece of legislation that upholds the rights of individuals engaged in legal reproductive healthcare services in New Hampshire. By providing legal protections, preventing extradition, and safeguarding confidentiality, this bill contributes to the preservation of statutory rights and the privacy of those seeking reproductive health care in the state of New Hampshire. These are dangerous times for pregnant people, and I can share a few reasons why we should hasten passage of a shield law. Idaho, which has banned abortion at all stages of pregnancy, has become the first state to adopt an abortion trafficking ban. In Alabama, where abortion health care is illegal, the Attorney General argues that he can file criminal charges against people who assist those in getting abortion. The Attorney General in Alabama argues that he can file criminal charges against people who assist those getting abortion care outside of the state. He also argues that people who organize travel for those leaving Alabama to receive an abortion, for example, may be participating in a criminal conspiracy because abortion is illegal in the state, claiming that the conduct is Alabama-based and within Alabama's power to prohibit. In Texas, a woman named Kate Cox, who bravely shared her experience. Her pregnancy was deteriorating rapidly due to a lethal, fatal fetal diagnosis of full trisomy 18. Continuing the pregnancy posed a threat to Cox's health and future fertility, but her doctors refused to perform an abortion due to the state's near total ban on the procedure. She had to leave her state in secret to get the abortion she needed to protect her life and her future fertility. The landscape for abortion health care is unstable, and we need this shield law to protect patients and providers from the overzealous and cruel prosecutors who want to reach into New Hampshire to prosecute for legal transgressions in other places. We need to ensure protection for patients and providers. I urge you to recommend ought to pass on Senate Bill 575, and I am open to questions.
Thank you very much for your testimony, Senator. Are there any questions from the committee? Senator, I do have a question.
Yes.
I would like to refer to your proposal on page 1, section 2, beginning on line 19, where you discuss healthcare, the insurance, and how this is going to be interpreted by insurance coverage. And so are you proposing that if somebody from, you mentioned Texas, for example, or Idaho, or Alabama. Yeah. Wants to come to
Arkansas.
New Hampshire. Pardon? Arkansas.
Arkansas,
Okay.
Alabama, well, all of them, but yeah.
One of the A states. Anyway.
Yeah.
Wants to come to New Hampshire to have an abortion. Does that mean a national insurer like Anthem would have to cover the abortion?
So if someone in a state like Alabama or Arkansas were to come to New Hampshire for abortion health care, and their insurance company paid or reimbursed, this would say that Arkansas or Alabama cannot come into New Hampshire and request the verifying information that that procedure had taken place. So if their insurer, if they chose to use, or if they had insurance, and insurance, so on line 21, or provide insurance coverage for such services or care, so anything that is physically, like it says here, where you are physically, in line 23, if you are physically present in this state, and perhaps you have insurance that you have purchased in another state, and for the sake of argument, let's say it's Arkansas, and so you come here and you use some of your health insurance to pay for some of your health care. Arkansas cannot use that, and they can't come to New Hampshire and ask for that verifying information in order to prosecute you in Arkansas.
Okay, thank you. I'm trying to follow. I'm trying to follow this, and I know I've got a ton of questions because you're talking about, we as a state, we regulate intra-state commerce.
Yeah.
The federal government regulates interstate commerce because someone's coming here to buy a service that they cannot obtain in their home state. I think there's a lot of federal law around that. And I'm just wondering if you had looked into that. And perhaps, I think with insurance, I think it's going to get a little murky. So I'm not really clear about that because we have HIPAA. And usually insurance companies, they bill after the procedure is done. So I don't know how the federal government or even law enforcement is going to deal with that. We don't have anything on our books that even begins to remotely deal with this. We do not collect information on abortions right now anyway. So it's like how, and I know it's an insurance company thing, but I'm hoping that there might be somebody who deals with healthcare insurance that would be able to come in and answer some questions.
Yeah, it sounds more convoluted than it actually is. And what Section 2, lines 19 through 26 do is they provide a shield for patients who are traveling into this state, so that whatever they do while they're here, whether they use their insurance, whether they use a credit card from, like, for instance, if they had if they were part of a credit union in their local hometown, there are states like Alabama and like Arkansas who are arguing that any connection to the home state, even the planning of the trip to leave the state to seek abortion care services, is a criminal conspiracy. And so this part of the shield says that when you are moved to another state to receive abortion care, healthcare services in a state where it is legal, no part of that, the payment, involvement of an insurance company, a check written from a local credit union, none of that can be included in a criminal conspiracy charge, that New Hampshire will not participate in bolstering that so-called criminal conspiracy. That's the part, that's what this is addressing.
Okay, thank you.
Sure, thank you. Thank you for the question.
Okay, seeing none, thank you very much,
All right.
Senator.
Thank you.
Okay. There's not a lot of people that want to speak. Just a few. Okay. Okay, the chair will call Matthew Rhodes. Is he here? Did he come back? Okay. Okay, next we're going to call Kayla Montgomery.
One more time.
There you go.
All right. Good afternoon, Senators. My name is Kayla Montgomery. I am the Vice President of Public Affairs for Planned Parenthood of Northern New England and the Action Fund. And we are here today in support of Senate Bill 575. I will be brief here. So as this committee knows, after the Supreme Court's ruling in Dobbs versus Jackson Women's Health, all federal protections for abortion were eliminated. So during that, since then, in the last 18 months, many different legislatures and governors in states where abortion has remained legal have taken action to maintain abortion access. This bill before you is a type of legislation that we have seen in quite a few other states. It's generally referred to as something called a shield law. And Planned Parenthood supports this type of legislation because it aims to obstruct other states from enforcing anti-abortion laws against individuals who provide, obtain, or support abortion care in a state where abortion is legal, like here in New Hampshire. SB 575 aims to strengthen legal protections for patients and providers who are seeking abortion and contraceptive care. So we have not yet seen a hostile state take cross-border enforcement action. However, and the bill sponsor already listed a few of these examples, but individual lawmakers in hostile states have suggested that they would be interested in taking measures that would prevent people from traveling to access states like New Hampshire for care, and that type of, it would include potentially cross-border enforcement. So this bill gives protections for the people of New Hampshire from government overreach in other states. And we know that Granite Staters do not want politicians from other states to control what healthcare we can and cannot receive in our own state. And so ensuring that healthcare providers can offer the care they're trained to provide without fear of adverse actions is essential to safeguarding all medical care in New Hampshire. And Planned Parenthood supports the strengthening of our laws to support our patients and our providers. I'm happy to take any questions.
Thank you very much for your testimony. Are there any questions from the committee? Senator Abbas?
Thank you, Madam Chair. If I understood your testimony correctly, there's no pending legal cases where I think you call them a hostile state sought prosecution for someone who left their state to get an abortion in another state. Did I understand your testimony correctly?
Yeah, that's correct. We have not seen that actually happen yet at this time, but we know that there's lots of examples of states that are trying to take that action. So these laws haven't gone before the court yet. They're largely untested. And I'll also note that they're also new. So the state of California put one through last session. It just went into effect on Monday. So we will likely see court actions in this soon. And that's why having those protections on the books in New Hampshire would preempt that.
Follow up.
So I understand in having this in New Hampshire, but let's say another state, like whatever state, Texas, whatever, wouldn't we have no impact on stopping their prosecution?
I'm sorry.
How would we stop Texas from prosecuting someone?
So this bill, it provides a number of assurances in different ways, 4 different ways, that would just say that the state of New Hampshire wouldn't comply with that. There's a couple of different, I think there's 4 sections that list out different ways to protect patients and providers, making sure that states can't reach into New Hampshire.
Thank you.
I just have a quick question. In looking at, on page 1, on line 5, where you define reproductive health care services, I think it's important that we note that this is not only about abortion. This is quite extensive. So I just want to make that point, that this is not just about abortion. This is all services, care, or products of a medical, surgical, psychiatric, therapeutic, diagnostic, mental health, behavioral health, preventative, rehabilitative, support, consultative, even consultations, referral, prescribing, or dispensing nature. This is very, very extensive. So I think we need, in my opinion anyway, we need just to be well aware of that. And so hopefully we'll get a lot of testimony about that, the other aspect of this, because right now we have telehealth, people that are crossing state lines, and it's kind of new, especially here in New Hampshire, something that was a result of COVID. So, again, I just want to make a point to my fellow committee members, as well as to the audience, and as well to the people that are listening and watching on YouTube, that this is very, very extensive. This does not deal specifically with abortion. This is all healthcare, quite frankly, in my opinion, the way this reads. So, again, we just to let people know.
And I'm sorry, I know that wasn't a question directed at me, but
Right.
I would just like to add that, of course, if you or if this committee was interested in continuing this conversation and potentially making changes to this bill, Planned Parenthood would certainly love to have a seat at the table in helping to craft something like that, as the largest provider of sexual and reproductive health in New Hampshire.
Thank you very much.
Thank you.
Any further questions? Senator Abbas?
Thank you. You mentioned that California recently adopted some provisions on this topic. Is this proposed legislation similar to what California adopted?
I certainly am not an expert in what California did, but I believe it's a little bit different. I think it's more specific on telehealth in California.
Thank you.
Okay. Sure. Any further questions? Seeing none, thank you very much, Ms. Montgomery. Okay, next we are going to call Dr. Danielle Albushis. Did I get that correct? Good afternoon, doctor.
Chairwoman Carson and members of the Senate Judiciary Committee, my name is Danielle Elbushies. I'm a practicing OBGYN in New Hampshire, and I'm here today to express my support alongside many of my colleagues and the New Hampshire Medical Society for SB 575, relative to legal protections for legal New Hampshire abortion and contraception care. Since the fall of Roe v. Wade in 2022, we've all seen and heard so many stories. Stories of the injustices, fears, and dangers that women seeking health care, specifically abortion care, have experienced in states around the country that have outlawed the provision and access to such health care. Stories detailing how patients must flee their home state, should their socioeconomic status allow, to receive abortion care. Many fleeing their state to receive care because their lives actually depend on it. As we've heard, look at Texas, Mississippi, and Idaho. So many stories, and for the sake of time, I would not go into these stories here today, but New Hampshire does not want to have any part in these stories. Prior to the Dobbs decision, efforts by reproductive rights advocates were characterized as alarmist when speaking to the dangers facing women, dangers to their physical health and mental health, should we lose decades of precedent and protections with the fall of Roe. Roe fell, and now we have countless heartbreaking stories that point to just how right we were. We're not being alarmist, and in this time around, we must do everything in our power here in New Hampshire to ensure that the dangerous, life-threatening laws of other states will not be carried out by our state's government officials, nor should our healthcare providers be subject to withhold care for fear of criminal penalties. As a physician, I'm truly grateful that I do not have horrific firsthand stories to share of this happening in New Hampshire. I'd like to keep it this way, and this bill would help do just that. For these reasons, I urge the Senate Judiciary Committee to recommend ought to pass on SB 575 so that we can send a loud and clear message. New Hampshire state government and law enforcement will not indulge or cooperate with the demands of states whose laws deny their citizenry the reproductive rights and freedoms. Thank you for your time and consideration of this testimony.
Thank you very much for your testimony, Doctor. Are there any questions from the committee? Okay, seeing none, thank you very much. The chair will call Matthew Hood. Good afternoon, Mr. Hood, a former colleague of ours. It's good to see you again.
Good afternoon, Madam Chair. It's nice to see you as well, members of the committee. For the record, Matthew Hood, Vice President of Government Relations for Dartmouth Health. And I'm here to share Dartmouth Health's support for Senate Bill 575 for two of the reasons in particular. One is the prohibition on extradition assistance, and the other is on licensure implications for providers. So I will ask not to receive questions about insurance, as I won't be able to answer them, Madam Chair. So the chair of our OBGYN department and I have been before this committee to testify previously in connection with the repeal of criminal penalties that exist on New Hampshire's post 24-week prohibition. The reasons for supporting this bill are very similar, and they're really twofold. I'm going to focus on two populations. One is current providers, and the other is, as an academic medical center, we also educate the next generation of providers. The concern has been the implications for care that our current providers will be able to provide. What do I mean by that? I mean by that Hanover and Lebanon, where Dartmouth Hitchcock is located, there's a college there at which probably all 50 states are represented with young college-age people who probably come in for services. As the state laws change, are we to be fearful for the services that we provide to those college students based upon their state of origin? It's unknown. The message, this is actually, I think, one of the most important things, and the previous provider who testified, I think, said it eloquently. It's not hyperbole to say that our providers are concerned and fearful because of the uncertainty. This bill would send a message to our providers: we have your back. You're providing a service that's legal in the state of New Hampshire, and we're going to protect you from other states coming in to punish you for providing a legal service. The second population, of course, is the trainee population. And the fear there is that providers will be less inclined to enter a field in which they're subject to prosecution or challenge. And what does that mean for the future of specialists in the state of New Hampshire? And I'm not exaggerating when I say it's a small population of subspecialty providers. So I actually think I'm going to stop there and happy to take questions. But for those reasons, Dartmouth Health supports this bill.
Okay, thank you very much for your testimony, Mr. Hood. Senator Abbas and then Senator Whitley.
Thank you, Madam Chair. And thank you for your testimony. Is it that doctors are afraid here in New Hampshire of being prosecuted by other states, even if they've never been to that state before?
Yes, it's the patients who receive care who originate in a state that prohibits services that are legal in the state of New Hampshire would be prosecuted by those states.
But would the doctor or physician be, or the nurse practitioner, would they be subject to prosecution even if they've never been to that other state?
Could you repeat the question, please, Senator?
I'm asking, would the doctor or the nurse practitioner, would they be subject to a prosecution of another state, even if they've never been to that state?
I can't answer the question of interstate prosecution and criminal law. I can't. I'm not evading your question. I think that there's a genuine fear, though, in the provider community that they could well be. And again, this type of legislation would send a message that we're going to protect you should you see efforts from other states to prosecute you for providing that care.
Thank you.
Okay, Senator Whitley.
Thank you, Madam Chair, and thank you for taking my question. There was a conversation, and the chair raised an important issue about sort of the breadth of this bill. So do you have the bill in front of you?
Yes.
Okay. What a good former senator.
Sorry, yes, I do. Senator.
So the way that I read it is that we are talking about reproductive health care services, and then we list a whole bunch of them. And then on line 8 that we say, we sort of limit it related to the human reproductive system. So as I read it, it is sort of limited to these reproductive and sexual health services. Is that how you read it?
Well, I haven't had a conversation with the drafter of the bill, but my assumption is that it was trying to be comprehensive with respect to the scope of reproductive health services that could be provided. So it's not limited to abortion services exclusively. I actually think it's not a bad message to send it as broad as it can be. Notwithstanding Madam Chair's concern about that, I actually don't think that's a bad thing. We're telling our healthcare community, we trust you. We trust you in the care that you're providing to people in the state of New Hampshire, whether it's reproductive health space, cardiology, diabetes care, whatever it might be.
Yep, follow up.
Yeah, and I think to me, I see it as limited to sort of reproductive healthcare services, but I think you're correct in that could include birth control. And, it's not far-fetched to me in this type of political climate that, it could be an anti-abortion politician wants to eventually go after birth control. It's not, it's in the realm of possibility. So my understanding is that this would cover that as well. Is that your assumption?
So I would, I'd actually like to add two things if I can. One is, and I forgot to mention in the testimony originally, family practice doctors, in addition to the OBGYN practitioners, have shared concerns because they obviously take care of young people, old people, people within the reproductive years, as well as people at the end years. And they also, they provide this care. And so they're not immune from the risk of, or the fear of the risk of prosecution for providing services to others. So thank you for that reminder. And then can you refresh my recollection as to what your actual question was? I apologize. I went on to my second point.
You answered it.
Okay. Are there any further questions? Seeing none, thank you very much.
Thank you very much, Madam Chair, members of the committee. Happy to answer any questions in the future.
Thank you. The chair will call Alice Wade. Good afternoon, Ms. Wade.
Good afternoon, senators. My name is Alice Wade. I'm a trans woman and a board member of Assisted Great Quality, a grassroots organization fighting for LGBTQ plus rights here in New Hampshire. I'm here today to support SB 575 and to recommend the addition of gender affirming care to the bill to support LGBTQ plus youth and adults. Gender-affirming healthcare and abortion are under attack across the U.S. and here in New Hampshire. Healthcare that saved my life 5 years ago is now being taken away by politicians going against the recommendations of doctors and every major medical organization. I can't express to you how dispiriting it feels sitting here today to have less rights than I did yesterday. This morning, HB 619 and HB 396 in this very building has made this a dark day for civil rights in New Hampshire. Despite the fact that pro-LGBTQ+ and abortion protection bills have often had the most public support of any legislation in recent history, harmful restrictions continue to pass here and around the country. The people of New Hampshire are watching their liberties being stripped away one by one, and you, as members of this committee, have the power to stop that. The need for reproductive health care protections is far more pressing than ever after the fall of Roe v. Wade. The subsequent attacks on abortion rights and gender-affirming health care throughout the United States, including right here in New Hampshire, have been horrific to watch unfold. Every day, more stories are coming to light about the dangers that these restrictions bring. As I'm sure you've already witnessed, Kate Cox recently had to flee Texas to get an abortion after the state's attorney general personally threatened to prosecute her hospital when her fetus wasn't viable and her health was in danger. Brittany Watts in Ohio was charged with abuse of a corpse when she tragically miscarried in the toilet. Women across the U.S. have been forced to wait until they're considered close enough to having their life at risk to get an abortion. New Hampshire needs this law now more than ever, particularly protections against other states interfering with New Hampshire's healthcare. The risk of other states trying to prosecute doctors and hospitals for providing healthcare to out-of-state patients is no longer just a warning. It's already happening. Ken Paxton, the same Texas Attorney General I mentioned before, is attempting to sue a Seattle Children's Hospital for providing gender-affirming care to people from Texas. We can't let other states tell New Hampshire doctors how they are allowed to practice medicine. I implore you all to please approve SB 575 and add in protections for gender-affirming healthcare as well. Thank you, and I'll hear any questions.
Thank you very much for your testimony, Ms. Wade. Are there any questions from the committee? Seeing none, thank you.
Thank you.
Okay, the chair will call Dave Testerman. Is he here? Okay, he's probably upstairs. Okay, next we will call Jason Hennessy. Good afternoon again, Mr. Hennessy.
Good afternoon again, and thank you guys for your patience. You have a lot of attention span, and I respect that a lot. My name is Jason Hennessy. I'm here to represent the many New Hampshire pro-life people as the president of New Hampshire Right to Life. I have a PhD in computational sciences and statistics, which helps me to look at the research around these things. As I was looking at this bill, so we oppose SB 575, and as I was looking at this, it kind of struck me that this would specifically shield the abortion industry from scrutiny. What other industries enjoy that kind of protection? I mean, there might be a few, but not that many, where we carve out and we say, we're not going to help other states prosecute or otherwise enforce their laws for people from their state. So, as was testified, there weren't any actual examples of where this was needed. So, I mean, right out of the gate, we know that this is a solution in search of a problem. But I want to ask you, what would the unintended consequences be? For instance, what about insurance fraud? Would that be inhibited by this? What about Medicaid fraud? What about malpractice lawsuits? I mean, remember, as Senator Carson pointed out, this isn't just limited to the specific abortion industry. This says reproductive care. So if there's a botched C-section or something like that, or some gross negligence, what would the consequence of this law be if it were to pass? We would be preventing actually protecting women, which is a huge part of what the state is supposed to do, by removing those protections from civil lawsuits. If people knew that they could just come to New Hampshire and both they and their assets would be protected, we would essentially be doing harm nationally. So this bill removes a level of oversight that we have right now. And lack of oversight was one of the main reasons why this particular abortionist in Pennsylvania, Kermit Gosnell, was able to get away with it. It was because the state was not enforcing the laws. What if other states and attorneys generals are looking into, let's say, national healthcare providers or abortion providers like Planned Parenthood, and they can't because New Hampshire won't cooperate with them? So I urge you, senators, to oppose this bill, and I would be happy to take any questions.
Thank you very much for your testimony, Mr. Hennessy. Are there any questions from the committee? Seeing none, thank you.
Thank you.
Are there any other members of the public that would like to speak to Senate Bill 575? Please come forward, and please state your name for the record.
Good afternoon. My name is Bill Blum from Portsmouth, New Hampshire.
Excuse me, Bill Plum?
Blum, B-L-U-M.
B-L-U-M, okay, thank you.
You're welcome. I am non-binary and use they, them pronouns. I am a co-founder of 63 Equality, here to speak in support of SB 575. I'm not going to waste everyone's time in repeating what's already been said about the bill, but I want to point out the chairwoman's concerns or point that was made earlier about it's an extensive policy, healthcare legislation. However, it's missing one key point, and that's protections for gender-affirming care. I find it interesting to put in protections in place around reproductive rights and at the same time leave out space for protections about a lesbian couple that is pregnant. And there could be challenges with that because the woman could face ridicule, prosecution from somewhere else based on the gender identity or sexual preference in this case. So I would like to see an amendment to add that language into this already good legislation so that we can continue to protect the large community as a whole. So thank you so much.
Okay, thank you very much for your testimony. Are there any questions? Okay, seeing none, thank you.
You're welcome.
Again, are there any other members of the public who would like to speak to Senate Bill 575? Okay, seeing none, we'll close the public hearing. Check that one out, public house. That means we're gonna go. Okay. Okay, no, we're going here. You're not Senator Altshore.
Okay. I don't have the bill.
Okay.
So mine is not next.
No, you're right. Yeah, no.
Oh, okay.
Well, we just had Senator Altshore twice, and she's on the next one. So, but I scheduled this, I think, like 2 or 3 weeks ago.
I could play the part of Senator Altshuler.
She's sitting in back and she's going, what? Okay, just let me see who wants to speak. Nobody's speaking. That's a good thing. Okay. Are you all set? Matthew, you all set? We're going to go ahead and open the public hearing on House Bill 461 and recognize the prime sponsor, Senator Rosenwald. Welcome, Senator.
Thank you. Good afternoon, Madam Chair and members of the committee. For the record, I'm State Senator Cindy Rosenwald from District 13, which is most of Nashua. I'm pleased to be here to introduce Senate Bill 461. This is a bill to remove confusion in state law. It will provide clarity for New Hampshire women that they have the right to abortion and therefore can claim agency over building their families and determining their own futures. It does so by repealing RSA 329:49, one sentence in the Fetal Life Protection Act that says, "Nothing in this subdivision shall be construed as creating or recognizing a right to abortion." We know from poll after poll that Granite Staters are not only strongly pro-choice, but that access to safe legal abortion is one of the top issues that drives voters' choice of candidates when they cast their votes. Last session, I listened to a lot of debate on the Senate floor on the issue of the right to abortion. And I think I kept my mouth shut the entire session, but I was listening carefully. There was a lot of back and forth between those senators who stated there is no lack of clarity in state law, that people do have the right to abortion, and senators who claim state law does lack clarity and is confusing because of the sentence in 329:49. The repeal of Roe through the Dobbs decision has thrown the issue of access to abortion to the states. So repealing the sentence that state law does not create or recognize a right to abortion is critical to reassuring patients and doctors that abortion is legal in New Hampshire. Thank you, Madam Chair. I'd be happy to take questions.
Thank you very much, Senator Rosenwald. Are there any questions from the committee? No, seeing none. Thank you. The chair will call Liz Canada. Good afternoon again, Ms. Canada.
So good afternoon. Thank you. My name is Liz Canada. I'm the Advocacy Director of Planned Parenthood New Hampshire Action Fund and Planned Parenthood of Northern New England. We're here in support of Senate Bill 461. New Hampshire, we don't have an affirmative right to abortion. We don't have an explicit right. In previous sessions, we've heard lawmakers say that because we have an abortion ban at 24 weeks, there's therefore the right prior to that. But it's legal before 24 weeks, but there isn't the right there. And here's how we know there isn't the right. RSA 329:49 states, "Nothing in this subdivision shall be construed as creating or recognizing a right to abortion." So this bill removes that line from the statute, from the 24-week ban. It offers clarity with what some lawmakers have said is their intent or what they want to be true about the 24-week ban. So we would urge you to vote ought to pass on Senate Bill 461.
Thank you very much, Ms. Canada. Are there any questions? Senator Abbas?
Thank you, Madam Chair. and Thank you for taking my question. If Senate Bill 461 were to pass and that one sentence was repealed, can you tell me how would that change the application or impact on the Fetal Life Protection Act?
Thank you for the question. So I think what it would offer is clarity to folks who've heard about the 24-week ban, know that it is in place, and opens the door for amending the New Hampshire Constitution to add the right explicitly. So this wouldn't add it explicitly into law, but it would remove that line about how the 24-week ban does not create or recognize a right to abortion.
Follow up?
Thank you. And just to follow up, when you say this ban, can you describe the ban that you're speaking about?
Sure. It's the ban that passed in 2021 and took effect January 1st, 2022. It is a ban on abortion at 24 weeks. The ban was amended in the next year. It was amended by this committee to add fatal fetal diagnosis as an exception. It also has a narrow exception for the physical health of the pregnant person as well. So that is the ban that is in place. But this RSA specifically says, even with that ban in place at 24 weeks, there is no right to abortion prior to that.
And
Follow up?
And can you describe, is there any ban prior to 24 weeks?
No, there's no ban prior to 24 weeks. As I said, it's legal, but it's not protected and there's no right prior to 24 weeks. So a future legislature, of course, can change that through bills that are passed.
Thank you.
Sure thing.
Are there any further questions? Okay, seeing none. Thank you very much.
Thank
Ms. Canada. Okay, the chair will call Dr. Maria Boylan. Good afternoon, doctor.
Good afternoon, Chairwoman Carson and members of the Senate Judiciary Committee. My name is Dr. Maria Boylan, and I'm a family medicine physician in New Hampshire, and I'm here today in my official capacity as president of the New Hampshire Medical Society. I'm here to express the Society's strong support for SB 461, legislation seeking to ensure that there is clarity in our state law when it comes to the right to access abortion care in New Hampshire. Since the implementation of the Fetal Protection Act in 2021, state law has lacked affirmative language that tells the residents of this state, physicians, and patients that they have a right to abortion care in New Hampshire up until the limits set place 2 years ago. This fact, coupled with the fall of Roe in 2022, our patients have not only been left with feelings of confusion and uncertainty about their right to make reproductive health care decisions, they have been fearful that their rights will further be restricted as a result of lacking state and federal protections. The patients of this state deserve better. They deserve clarity in the law, and this bill will provide such clarity. One of the greatest honors of my life is being a family practice physician and caring for my patients. I have the privilege of caring for people from birth till death, caring for entire families in multiple generations, and watching them grow as well as helping them through their most difficult times. And for some women and families, that includes making one of the most personal and complex health care decisions of their life, which would include terminating a pregnancy. And though there are numerous reasons why patients elect to have an abortion or medically need to have an abortion, that decision is one that should solely rest between the patient and their healthcare provider. A decision I know firsthand is never taken lightly, a decision that surely should not be restricted or influenced by actions taken by our elected officials. Being a good physician to me means protecting my patients in a variety of ways. And that includes keeping the government out of our hospitals and exam rooms. Healthcare should not be dictated or influenced by politics. Abortion care is healthcare, and every patient has the right to quality, safe, and comprehensive reproductive care. For those reasons, I urge the Senate Judiciary Committee to recommend ought to pass on SB 461 to make clear to our patients, your constituents, have a right to access abortion care in New Hampshire. Thank you for your time and consideration.
Thank you very much for your testimony, Doctor. Are there any questions from the committee? Senator Abbas?
Thank you, Madam Chair. You testified that you have patients that come in quite frequently that are confused about what the law is in New Hampshire. Did those patients read the Fetal Life Protection Act?
I'm sorry, what did you say?
Did the patients that come in that are confused about the law in New Hampshire, did they actually read the Fetal Life Protection Act?
I don't believe I said the patients are confused. I said it leads to confusion amongst patients and physicians. They're coming and making difficult decisions about their health care in terms of whether or not to terminate a pregnancy. But this law has confusing language, and by striking that line, it leads to more clarity that they do have the right to abortion up till the 24 weeks.
And if I, as
Follow up?
well,
Yep.
I have the, are you going, when the patients come into your office, I'm not trying to ask you to divulge any confidential information, but are you going over the Fetal Life Protection Act with them? I guess I'm wondering, well, what are they confused? Where's the confusion
When
coming?
I say our patients, I mean our patients of the state of New Hampshire. I'm not talking about personal instances inside my exam room. I try to keep healthcare in the exam room.
Are you all set?
Thank you.
Okay. Thank you.
Can I follow up?
Of course, Senator Gary has a question.
So to me, it was always crystal clear, 24 weeks, exceptions, health of the mother. Wasn't that always clear to you once we passed the law?
It's clear until you get to that line that says that nothing in this Fetal Life Protection Act shall be construed as creating a right to abortion.
Okay,
So
thank
the
you.
law is perfectly clear, and then you get to that, and it feels very confusing at the end.
Okay, thank you.
Okay, thank you very much for your testimony, Doctor. Okay, the chair will call Courtney Reed. Good afternoon, Ms. Reed again.
Thank you. Thank you for giving me the time to speak. Once again, my name is Courtney Reed. I'm supporting SB 461 on behalf of the ACLU of New Hampshire. I just wanted to echo some of the other affirmative statements we've heard today, that SB 461 would be a pivotal first step to establishing an affirmative right to abortion in New Hampshire, whereby the current law, which expresses that there is no right to an abortion, leaves granted staters completely unprotected from future attacks that would further restrict access to abortion in the state. I wanted to recommend to the committee to pass this bill because it adheres to what public health experts recommend, and that it's an opportunity to protecting the right to abortion in the state, which is long overdue in New Hampshire. I also wanted to cite an example where something similar to SB 461 has happened in Michigan after the state passed a constitutional protection for abortion rights. The state then repealed a law that banned abortion in the state. I think that this demonstrates that harmful laws like RSA 2949 are not compatible with the other protections for abortion that we're hearing today. So passing this bill, in addition with other affirmative laws, would add clarity that constituents in New Hampshire have an affirmative right to abortion.
Okay, thanks. Thank you. Are there any questions? Okay. Seeing none, thank you very much for your testimony.
Thank you for your time.
Okay, and I will call Jason Hennessy. Mr. Hennessy?
Thank you for taking my testimony for a third time. My name is Jason Hennessy from New Hampshire Right to Life. So I just wanted to point out that this particular RSA is an important part of the bill because it's hard to control what judges down the line are going to say. I mean, people can, if you pay attention to the legal community and the decisions over time, I'm sure you can find some decisions that you disagree with on interpretations of passages. And what this particular line does is it clarifies what the legislature was thinking. So what I've heard a lot here is that we need an affirmative right. We need an affirmative right, but this law doesn't actually do that. This law just takes away a line that says this law shall not be interpreted to create an affirmative right. It does not actually create an affirmative right. So if that's your goal, this bill is not the right bill for you. Next, it's clear that the legislature has chosen not to create a right. Just last year, in this very committee, HB 88 and SB 181 were proposals to do that, and you chose not to do that. In terms of whether there's confusion, the last point that I've heard is in terms of confusion over whether abortion is legal up until 24 weeks / 6 months. You can just go to the internet. I just back there typed in NH abortion law, and Wikipedia and Planned Parenthood both say it's legal right up to 24 weeks. So if there's confusion, I'm not sure where that's coming from. And with that, I would be happy to take any questions, and thank you for your time.
Thank you very much for your testimony, Mr. Hennessy. Are there any questions? Senator Abbas?
Thank you, Madam Chair. I asked this question previously, but if the last provision of that last sentence of the Fetal Life Protection Act were to be stricken from the law or repealed, how would that change the application of the Fetal Life Protection Act? Or would it change it at all?
Thank you for your question, Senator Abbas. As a non-lawyer, I don't know if I feel qualified to answer that.
Are there any questions? Seeing none, thank you very much, Mr. Hennessy.
Thank you.
Okay, are there any other members of the public that would like to speak to Senate Bill 461? Okay, seeing none, I'm going to close the public hearing. Thinking of you. How you doing? Hanging in there? I thought you were leaving us for a second.
I'm out of here. Yeah. Can you imagine?
I really appreciate all of you staying here and answering our questions. So thank you to the audience. Okay, we're going to go ahead and open the public hearing on Senate Bill 567 and recognizing our own Senator Whitley.
And thank you, Madam Chair, to you for running a very respectful committee and making sure everyone is heard. I truly appreciate that. So good afternoon, members of the committee. For the record, my name is Becky Whitley, and I'm honored to serve District 15, which includes the wonderful communities of Bow, Concord, Pennacook, and Hopkinton. Just very quickly, this is a very simple bill. In short, this bill requires the Department of Health and Human Services to protect and expand access to critical medications for reproductive health that are approved by the Food and Drug Administration, including, but not limited to, essential healthcare like medication abortion. You all may know now that mifepristone was first approved by the FDA more than 20 years ago and has since been used by more than 5 million people in the U.S. to safely end their pregnancies and for other medical issues. The legislature of the state of New Hampshire has actually recognized the importance of access to mifepristone since 1991, when New Hampshire was the first state in the nation to adopt a state resolution urging the U.S. Food and Drug Administration to allow clinical trials of mifepristone in medication abortions. The same drugs used to produce a medication abortion are also used to treat a miscarriage, which, if left untreated, can put patients at risk for severe infection, future infertility, or even death. This method of care has helped ensure that patients are able to make their own private medical decisions and has expanded access to reproductive health care, something that is under dire threat in this country. This is even more important in rural states like ours. But medication abortion, unfortunately, has now become the latest target by extremists to remove even more access to abortion care in our country. If successful, anti-abortion activists who are trying to eliminate access to medication abortion will be increasing the chance of poor health outcomes for all pregnant women, not just those who have chosen abortion. I want to be clear that attacks on mifepristone are strictly politically motivated, instigated and funded by extreme actors to further their agenda to ban abortion, birth control, and other sexual and reproductive health care nationwide. But we will not let this happen in New Hampshire, not on our watch, not in the live free or die state. New Hampshire has been and continues to be very much a pro-choice state. A survey from Breakthrough Campaign shows that a supermajority of Granite Staters, 87%, support reproductive freedom, and 64% of Granite Staters expect state elected officials to protect or expand abortion rights. With that in mind, last June, my colleagues and I asked Governor Sununu to take action to protect access to abortion, and more specifically, to protect access to abortion by joining a lawsuit to protect access to mifepristone, and to also issue an executive order like so many governors had following the Dobbs case, which overturned Roe v. Wade. Unfortunately, Governor Sununu failed to take any action to protect reproductive freedom or mifepristone in New Hampshire, which is why this bill is necessary. I respectfully ask that you stand with me to protect reproductive freedom in the Granite State and support Senate Bill 567. Because we are so late in the day, there are some folks that had to leave, so I wanted to call your attention to some testimony provided by Dr. Elizabeth Wilson, who is a primary care provider in Dartmouth. And what I think is important from her testimony is that sort of later down in her testimony, she says, I quote, medication abortion has helped people in rural areas with little access to care and people who can't travel or take time away from work safely access abortion. Imagine the young college-age women who is likely to access healthcare only through her primary care medical home. If she has an early miscarriage but has not seen her OB provider or established a relationship with one for the pregnancy, she is likely to call her PCP. We want to continue to be part of her healthcare, which access to abortion medication and primary care enables. I also want to call your attention to some testimony from New Futures, who also support the bill. Lastly, I want to be sensitive to the legal landscape here, which is quite complex. And so if you turn to page 2 of the bill on line 15, I would like to add a clause at the end of that sentence. So it says, nothing in this section shall diminish any existing authority of the department or require the department to conduct any activity in violation of state and federal law. And that just protects them from the significant shifting legal landscape. Thank you, and I'm happy to take any questions. Technical questions about mifepristone surely could be answered behind me.
Thank you for your testimony, Senator. Are there any questions? Senator Abbas?
Thank you for taking my question, and thank you, Madam Chair.
I'm sorry?
Thank you for taking my question, and thank you, Madam Chair. In respect to the law as it is today, how exactly does DHHS expand access to other medications?
Yeah, that's an important question. So, and it's a complicated one because of the Executive Council's decision to end many of the family planning contracts. That was an unfortunately political decision that's impacted the health and well-being of many of our individuals. And so I think they are limited at this point in terms of expanding access because of that limitation on family planning. But hopefully, again, with a shifting legal landscape, once those family planning contracts are renewed, they will be able to participate in the protection and expansion of access to critical medications.
Follow up?
So hypothetically, if a new antibiotic came out, for that to be available in the state of New Hampshire,
I'm sorry.
if a new antibiotic were to become available, how would that become available in the state of New Hampshire? Would it have to go through DHHS? Do they have the authority to do that already, or is there a process for that medication to be sold in the state?
About antibiotics?
I'm saying hypothetically, if a new medication came out.
I'm not aware about the process for other medications. I do know that access to medication abortion is well within the family planning contracts and the Title X programs that the department is involved in.
Thank you. I just have a question. So today.
Yes.
And I always watch how I say this, mifepristone?
Yep.
Okay, there we go. Is it, if I was to go to my private physician and ask to have this medication, would I be able to get it?
Yes, and that's a very important question. So this case, access to mifepristone right now is safe and legal in New Hampshire. The issue is very much at risk based on a case that is currently in the Supreme Court. Thank you for that question.
Thank you. That was my next question, because I know that there is currently a case in front of the U.S. Supreme Court, and I'm hoping that they will rule by June of this year. So I can understand why in that section on line 15, you would ask us to include any federal decision, because basically you're asking the state of New Hampshire to defy the federal government if there should put restrictions on
Mifepristone. Yeah, that's why I do think that additional clause is really necessary on line 15.
Okay.
Yeah, thank you.
All right, thank you very much. Are there any further questions? Okay. Seeing none, thank you.
Thank you.
Okay, next we're going to call Dr. Richard Johnson.
Thank you, Madam Chair and members of the Judiciary Committee. As I said earlier, my name is Richard Johnson. I'm a physician living in Dunbarton, New Hampshire. I guess I've been labeled by the good senator because I'm representing the unborn child as a radical position and a minority position in the New Hampshire Medical Society, but held by several physicians. To call abortion reproductive health care is simply covering up what's really happening. Abortion snuffs out a life. If that developing baby is a female, abortion erases her reproductive rights as well. The way to live with this dichotomy is to either say that the developing baby is not human life, or to say that this human life has no rights that we need to protect. Saying either allows us to have legislation like SB 567. I just want to call your attention to one thing under the observations, category 4. It states the drug is safe and effective. It is effective. Mifepristone blocks the action of progesterone, chemically destroys the baby's environment in the uterus, blocks nutrition to the baby, ultimately starves the baby to death in the mother's womb. It is effective. Is it safe? Well, it's not safe for the developing baby. Is it safe for the mother? A 2011 study found that more than 10% of women who took the abortion drugs needed follow-up treatment for an incomplete or failed chemical abortion. If the drugs were taken in the second trimester, 39% required completion surgical abortion. 20% of women have had adverse events after taking the drug, and that's 4 times more than adverse events from a surgical abortion. Chemical abortions are over 50% more likely than surgical abortions to result in an emergency room visit within 30 days of taking the drug. That translates into about 1 in 20 women. Compared to first trimester abortions, a chemical abortion done in the second trimester will result in twice as many infections and 6 times as many women will require surgery to complete the abortion. Currently, chemical abortion medication does not need to be dispensed or administered by a physician. The drugs can be obtained by mail order or telemedicine. No follow-up is required, and there is no requirement for reporting non-fatal events. So if we don't report events, I guess they don't happen. I would urge you to vote inexpedient to legislate. Thank you.
Thank you very much for your testimony, Doctor. Are there any questions from the committee? Doctor, I'm going to call on your medical expertise. This particular drug, is there a time frame? Because I was a little surprised to hear about second trimester. It was my understanding that this medication was made available during the first trimester.
That's where it's safest for the mother, yes.
Okay, so because you can get this online, you can telehealth, is there anything to stop anybody from taking it in the third trimester?
A woman can take whatever she wants. There's no law to stop her from taking it. In fact, in my news feed that comes on my phone over the app, that just the headlines, it was interesting. It said women are stocking up on mifepristone in case they'll need it. So I don't know what's behind that. I don't know why they would do that, but if you think you might be pregnant, maybe you take the drug.
Okay, what I find concerning is that there's no medical follow-up. I would hope that if a woman decided this is what she wanted to do, that she would go to her healthcare provider.
Right.
And
So
this is what they would do rather than getting a drug from online that you don't know really anything about. And not having follow-up care. You talk about sometimes this drug really doesn't work very well. And I think it puts a woman in a very critical health crisis that now they must seek medical care, and there could be long-term damage that's being done. So am I
No, you're
speaking
correct.
out of turn? Is this
No.
something that physicians are seeing?
Let me be transparent. I'm not an obstetrician, I'm a surgeon. I'm a retired Dartmouth surgeon. I'm not an obstetrician. Recently, we had a conversation, physicians, and it was just what you said. It was a very unfortunate situation where the woman had taken the drugs and had sought medical care. It wasn't readily available. You know, I can't go into the details, but my colleague who was on the other side of the opinion, Dr. Young, who was here earlier today, basically said in that conversation, this is an indictment against the medical care that this woman got. So yes, if the people can fall through the cracks, and that's on us. You know, if a doctor doesn't see a patient in follow-up, or they are reluctant to, or they just pass it off to the emergency room, or the list goes on, that's very unfortunate. That's bad medicine.
Just a few more questions, and I hope you don't think I'm badgering you.
No, I'm not badgering.
If these instances happen, are physicians required to report them to either the medical society or to the state?
That's a good question, and I don't know the legal answer. Maybe somebody in the room does. I don't know the legal answer to that question, but I think that it is safe to say that when, okay, personal illustration without going into details and making it very quickly. I contended with medical care for a member of my family that I thought was suboptimal. I never got an answer back. I never got an answer back. I never got an answer back. I called legal counsel. Instantaneously, I had a conversation with the 2 head people in the hospital, and they listened to me. I don't know if that help answers your question.
Okay, thank you. And one final question. Because this medication is available online, is it available to minors?
I don't know. I don't know. Maybe another physician in the room knows the answer. I don't know the answer to that.
Okay. Thank you. Thank you very much,
Thank you.
Doctor. I appreciate your time and your expertise. Okay, next, Senator Perkins Coca, is she here? Okay, I'm gonna. She's not going to? Okay. Beth Scar? Good afternoon again, Ms. Scar.
Hi, yeah, I'm Beth Scare, mom from Nashua, and I'm here to testify in opposition to SB 567. One of the passages in the bill says that medication abortion is safe and effective, but the sponsors of this bill are ignoring the numerous and serious complications, sometimes fatal, that have been suffered by women who take the abortion pill, including uterine bleeding, hemorrhaging infection, and sepsis. So it says, from Charlotte Lozier, it says, chemical abortion has a complication rate 4 times that of surgical abortion, and as many as 1 in 5 women will suffer a complication. As many as 15% of women will experience hemorrhage, and 2% will have an infection. And chemical abortions are over 50% more likely than surgical abortions to result in an ER visit within 30 days. And also, in another section, it says, for many people seeking abortion, access to medication abortion is not a preference. It's critical for their access to care, including, but not limited to, survivors of rape or domestic abuse for whom medication abortion may be the only way they can terminate a pregnancy without risking detection and further abuse. So what they're advocating here for is for women who are being coerced into abortion by their abusers or sex traffickers to go along with these coerced abortions to escape further abuse. They're saying the quiet part out loud, that women need abortions because evil men demand they have abortions. And this goes against everything these sponsors claim they stand for. They claim they stand for reproductive autonomy, but this bill is taking their reproductive autonomy away. They aren't given a choice to keep their babies. They must have an abortion or else be beaten, or worse. There was a woman here in New Hampshire within the last few weeks who was killed, 8 months pregnant. We don't know the backstory. We may never know, but it concerns me. There was also a young woman at the Sununu Center who was raped by one of the prison workers and was taken to Planned Parenthood for an abortion, which was not her choice. And that was documented in the Boston Globe. She took the abortion pill. So I ask, how can these legislators, these sponsors, claim to be for women's rights and support coerced abortion? Please vote ITL on SB 567 to protect moms and babies. Thanks.
Thank you very much for your testimony, Ms. Scare. Are there any questions from the committee? Okay, seeing none, thank you very much. The chair will call Courtney Reed.
Thank you again, members of the committee, for taking the time to hear this additional statement of support for Senate Bill 567. I wanted to echo some of the statements about why it's more critical now than ever that New Hampshire invest in expanding and protecting access to reproductive health care, especially medication abortion, in light of politically motivated lawsuits that we're seeing come out of the Fifth Circuit that as soon as this year could have an effect that would be devastating to abortion rights nationwide. And while this bill cannot override federal court judgments, it can New Hampshire in a better position to ensure that Granite Staters are getting the best care possible among an increasing number of attacks on abortion. I wanted to add a little bit of data to the context of why mifepristone is such an important medication in rural states like New Hampshire. We've seen from 2017 to 2020, even before the fall of Roe, that the use of medication abortion increased 45%. This is really important for ensuring access to people who live far away from their nearest abortion provider, who may be immunocompromised, or who face long wait times for an in-person appointment. And in New Hampshire, only 23% of women live in a state, who are in New Hampshire live in counties with abortion clinics, and that nationwide, because it's becoming harder and harder to operate as a clinic that provides abortion care, more and more clinics are closing. And in fact, if this ruling were to have a devastating effect, we would see clinics close in neighboring states of Maine and Vermont, further bottlenecking access to services here in New Hampshire. So it's imperative that in New Hampshire, the state do all it can to research and invest in mechanisms that can best support people seeking the care that they need. And I just wanted to close that since New Hampshire is the only state in New England without affirmative protection for abortion rights, it falls behind what other states in New England are doing. For example, in Massachusetts, they had purchased a stockpile of mifepristone for prescribers. Although it's unclear what the use of that might look like should a negative ruling come out, I think it's important to look at ways in which the state can prepare for a possible ruling that would affect access poorly. Thank you.
Thank you very much, Ms. Reed. Senator Abbas has a question.
Thank you, Madam Chair. Thank you for taking my question. In the event that the Supreme Court did make an adverse ruling making, I won't attempt to pronounce the medication, but if it takes it off the shelves, what exactly would this bill do to then ensure medical abortion is still available?
Right. I thank you for your question. As I had stated, this legislation would not be able to override federal court judgments, but I think that the research and investigation piece of this bill is really important. And as we've seen in New Hampshire, there's been a lack of investment into reproductive services more broadly that's causing clinics to have a hard time staying in operation. And that has a cascading effect for abortion access in the state and in the region more broadly. And I think having that element of the bill is really important to making sure that the ecosystem of reproductive care in the Granite State can maintain and continue.
Thank you.
Thank you.
Hey, are there any further questions? Ms. Reed, just for 1 second, you had mentioned about the availability via telehealth and by mail is vital. And you mentioned to the population that this is important to, and you mentioned the immunocompromised. You know, I know here with COVID that people that are immunocompromised and they're really being very careful about where they go and what they expose themselves to. But in this case, this person has underlying very serious medical conditions. And I would hope that they would be discussing this with their primary healthcare physician before they took any medication, rather than just saying, I find myself pregnant, I'm just going to go online and I'm going to buy this medication and take it themselves without consultation of their physician. There can be some very, very serious health risks here. And so I'm just curious why you included immunocompromised.
Yeah, I think it's important that folks who can't make it to a clinic in person should still have access to medications that they might need. But I think the only folks that could deem that medical necessity and appropriateness would be the prescribers of that medication. And I think the physicians here and staff who deal with what it looks like to prescribe these things day to day would be able to answer that question better than I can.
Okay, thank you. Okay, are there any further questions? Seeing none, thank you very much.
Thank you.
Okay, next we have Dr. Danielle Albushis. We also have Dr. Maria Boyland. Would you like to come up together, or you wanted
He's the one who had to leave that I referenced in my testimony.
Dr. Boyland? Is it Dr. Boyland?
she's here.
Okay.
Thank you. Apologies.
Okay.
Oh, sorry.
Okay.
Thank you for your time. Also, after my oral testimony, I'm happy to, from an OBGYN perspective, kind of answer some of these loopholes or questions that have been kind of dangling out there, if you would like me to, or I can take one question at a time. So,
Please, you have testimony. I'm just gonna, it's written testimony. We're not execing these bills today, so we're gonna have a lot of opportunity to go through and read everything that everyone has given us. So if you could paraphrase this, and then we can start asking you questions.
sure.
Thank you.
Oh, sure. My name is Danielle Albushis. I'm a practicing OBGYN in New Hampshire, and I'm here to express my support along many of my colleagues from the New Hampshire Medical Society for SB 567. Although I'm happy to answer questions based on medical abortion, I wanted to focus my testimony on the role of mifepristone in the management of miscarriage. As I have a privilege to provide prenatal care and have delivered babies for 20 years and counting in New Hampshire, some of the most challenging conversations that I've had with patients is communicating the reality of miscarriage. The rate of miscarriage in the first trimester is quoted to be as high as 20%. So these challenging conversations happen frequently. We are taught to provide our patients options should there be a miscarriage, as far as expectant management, medical management, or surgical management. There is very good evidence-based medical management that includes the use of mifepristone and misoprostol. Medical management of miscarriage is highly effective, offers a patient control over the timing of when that miscarriage happens, and the patient avoids a surgical intervention that carries risks of rare things, but significant risk of cervical injury, uterine injury should a perforation happen, and also some women aren't appropriate to have surgical management of miscarriage because of fibroids and other things. We know mifepristones, we have safety data for 20 years. In fact, when comparing those two medications, there's a higher rate of side effects of the misoprostol compared to mifepristone. So this medicine is important as we fully inform our patients who commonly deal with miscarriage, that we need to include in the conversation of mifepristone how commonly, globally, and widely accepted it is as far as the use of management of miscarriage. So thank you for your time in this testimony.
Thank you very much, Doctor. Are there questions? Senator Gaines?
A quick question. Senator Carson already brought up, she was familiar with it used in the first trimester. In the
Yes.
second, is it predominantly like 80% at the first?
Yeah, so it should be, and I can go over some of the FDA approved things. I think to your point, Senator Carson, you don't want to feel like people are just calling for this medication. It's not that way. The FDA, in approving this medication, has made what we call REMS, the Risk Evaluation and Mitigation Strategy. So anyone just can't provide mifepristone. So you have to go through the appropriate hoops of saying you're following the risk evaluation and mitigation strategy. A patient has to be involved and in that conversation as well. And there's official things that are happening before this medication, typically 10 weeks. And so that is the standard of care typically, that it's around 10 weeks. It's a first trimester option. So I don't know that I would even speak to it as far as a second trimester option for medical termination of pregnancy. So I wanted to clarify that there are things that need to happen before this medication, whether in person or via telemedicine. There's background to that person providing that medication.
Okay. Senator Abbas and then Senator Whitley.
Thank you, Madam Chair, and thank you for taking my question. There were some questions and testimony about people that are ordering this medication online, when that happens, are they consulting with a physician or are they just going on a website?
There is a provider, it doesn't have to be a physician. There's been lots of data that I certainly can speak to some of it, but it can be a physician, a nurse practitioner, a physician's assistant who has the appropriate background to take a history, to know where the patient's gestational age is. These things are happening, even if it's telemedicine. There's good data to support that. The volume of mifepristone and misoprostol that is prescribed via telemedicine is just as safe in the literature.
Senator Abbas?
And just to follow up, and I know you can't speak on behalf of patients who go to online, but what is the reasoning that someone would go online versus come see you in person?
Yes, thank you for that question. It's really an access of care issue. So in New Hampshire, we see that in reality, remote. There's some women are hours away from anyone that they would see. So that access from a distance perspective, remote access perspective, financial perspective, there's many factors that would, but mostly, certainly in this state, would be just the remote nature of where so many patients live.
Senator Whitten?
Thank you, Madam Chair, and thank you for providing your expertise, because I do think that, unfortunately, we know that, mifepristone has just become the political sort of du jour thing that's being attacked. And so I think your testimony is critical because, and I would like to hear more about the use of mifepristone for other types of conditions, because my biggest concern is that we're going to reduce access to this critical care, and knowing, how common miscarriages is, and it's a very traumatic situation for most women, and so you want to make sure that they have a care that really fits their own needs, and that's why in the legislation, we were very conscious about saying we want to make sure the department is protecting and expanding access to critical medications for reproductive health care. We did not just limit it to mifepristone. That is certainly something we wanted to mention, but if you could speak in more depth about the uses for the other issues, I would appreciate that.
Yes, miscarriage is the big one. And as physicians, we are taught to put the most respect for randomized double-blind placebo-controlled trials. Those are vigorous studies. And so there is a vigorous study on many women studying the use of mifepristone and misoprostol for miscarriage. And what we know from those studies is that it is evidence-based medicine to offer women mifepristone and misoprostol in the management of miscarriage. It works better. There's less complications, less need for surgical procedures. The most rigorous study that exists was done on mifepristone and misoprostol. And so it's very important that women have access to this evidence-based standard of care that's global, not just the United States. So, and so again, to parlay on that safety data, because there's these rigorous studies, we also know that there's good safety data. The side effects of mifepristone and misoprostol, it's less than 1% that require emergency intervention for bleeding. The need for intervention after those medicines within the first 24 hours is 0.2%. And so I just want to, depending on where you look, you may find different data, but I'm going to data that I've been trained to look at critically and to believe from the American College of OBGYN, from American Board of OBGYN. Those are the statistics we believe, and we believe that this medicine is safe. And again, having studies to know that it's safe via telemedicine as well as in person because of some of those safeguards that are in place.
Thank you. Yep, follow up.
In addition to miscarriage, is it used for any other condition sort of not related to pregnancy?
Not that I would use. I think there may be others in medicine. There's so many other, misoprostol, for example, is a gastrointestinal medication. I don't use it for that reason. So I'm unaware. I can certainly get back to you, Senator Whitley, on that, but not that I know of. Yeah.
Okay, are there any further questions?
Just a little
Senator Gannon?
question. At what point does it become unsafe? in a second trimester? You said 10 weeks was like the ideal?
So if it is used, certainly the farther along a woman gets, the potential for rare complications such as bleeding gets higher. I can't quote that specifically.
Okay, thank you.
Okay, thank you.
Thank you for your
Are there any
time.
further questions? Seeing none, thank you very much, Doctor. We appreciate your time and your expertise. The chair will call Dr. Maria Boylan.
And here in my official capacity as the president of the International Society, and we are here to express a strong support for SB 567. For physicians and patients alike around the country, ongoing legal challenges to the FDA's approval of mifepristone has created unnecessary chaos around the status of the drug and future access to medication management for abortion and early pregnancy loss. Last year, a Texas judge, more than 2,000 miles away from New Hampshire, issued a preliminary ruling invalidating the FDA's 23-year approval of mifepristone, a drug that has decades of use that is proven safe and effective for abortions during the first 10 weeks of pregnancy. Mifepristone, along with other medications, are used as an alternative to surgical abortions in about 50% of patients receiving abortion care. Since there have been countless appeals and decisions that have resulted in restricting access to this essential medication. Access to this is essential health care. This year, the Supreme Court will be tasked with weighing in on the limitations of prescribing mifepristone. And as we learned with the Dobbs decision, our patients are at even greater risk of losing more of their reproductive health care rights. Despite science, despite the proven safety, and despite the medical necessity for safe, accessible abortion care. Restrictions on mifepristone will deny patients access to the most effective medication regimen for abortion care and management of early pregnancy loss, and will impose the greatest harm on those who already face significant barriers to obtaining reproductive health care, including people of color, individuals with low incomes, and those living long distances from healthcare professionals. Make no mistake, if mifepristone is banned or restricted in its use, this is a dangerous precedent that will surely bleed into other areas of medicine when we allow political trends to subvert the authority of government agencies such as the FDA, whose purpose is to protect public health by providing physicians and the public with proper guidance on the safety and efficacy of medications based on years of data, experimentation, and expert review. We cannot be naive enough to believe that this subversion will stop at just the mifepristone, and this cannot stand. For these reasons, I urge the Senate Judiciary Committee to recommend ought to pass on SB 567, allowing New Hampshire to be proactive and protect access to mifepristone, a medication that is essential for high-quality reproductive care. Thank you.
Thank you very much for your testimony, Doctor. Are there any questions? Doctor, I have a quick question for you. Right now, here in the state of New Hampshire, this is a medication that you as a physician can prescribe. There's nothing stopping you from doing that. So if this bill should die, what happens?
I think the point of the bill is to be proactive. We're seeing trends across the United States right now where this is definitely at risk. And it's something that we need to be face forward on, and we need to take a proactive approach with.
Okay, thank you. Yeah, I'm sorry, Doctor, Senator Whitley has a question.
Sorry about that. That did sort of jog our question. Thank you, Madam Chair, and thank you for taking another question. That
Thank
did
you.
sort of jog an issue with me that why this would be necessary. And I don't know if you're aware that in Massachusetts and other states, the governor has actually acted similar to this legislation, directing different departments to protect access proactively. And so I don't know if you're aware, we did ask the governor to act in this way and he did not. And so we felt it was necessary to do so, sort of seeing the legal landscape around the country. You aware?
I am. Thank you.
Thank you.
Thank you very much, Doctor, for your testimony.
Thank you.
The chair will call Phyllis Woods. Good afternoon, Ms. Woods.
Good afternoon. Thank you so much, Chairman Carson, for hanging in there and allowing us an opportunity to weigh in on this. I might be repetitive of a little bit of prior testimony because I think some things need to be repeated. And I also hope that I can shed some light and some answers on some of the previous questions you had. I certainly don't think it's a coincidence, and I don't think you do, that this bill is being introduced just as the U.S. Supreme Court is scheduled to hear the two cases brought by the Alliance for Hippocratic Medicine. They want to curb the uncontrolled and unsafe distribution of the drug. The original bill that was passed, or allowing, you see, in your bill, okay. In this bill before you, talks about that this is a safe, effective, and common medication, but you've already heard that chemical abortions are certainly not a good substitute for surgical abortion. The fact is that chemical abortions have 4 times the rate of complications of surgical abortions, and the rate of ER visits after chemical abortions have increased from the beginning since 2002 by more than 500%. See, originally, this medication, this bill, was approved by the FDA for 10 weeks, no more than 7 weeks at the time. And also required a physician to be dispensing this drug, and no less than 3 visits. It started to go downhill in 2016 when the FDA extended the gestation period from 7 to 10 weeks, increasing the possibility of complications that you've already heard. While at the same time, they stopped the requirement that complications be reported and required only maternal deaths to be reported. Now, problem is, most of the dispensing agencies, whether it's telemarketing or a doctor, are not following up on what the complications may actually be. The FDA also removed the requirement that only a physician could be dispensing this, and dropped the required visits from 3 to 1, which further inhibited the safe health care of the women. Now, in 2021, it took an even further turn for the worse when they removed any in-person dispensation requirements, allowing women to obtain chemical drugs without seeing a medical professional. It's gone south since the COVID and the advent of telemedicine. The thing that you had brought up, Madam Chair, about who can obtain this through telemedicine and through the market. There is no check and balance and absolutely no requirement that they know the age of the person that, or even the sex. Certainly, it could be sex trafficking. It could be the father of the unborn child that actually procures the drug. But the problem is, this could also be a minor child, 14, 15, or 16-year-old that really has no way of that often they don't even know when their last period was, so they don't even know themselves how far along they may be. Because of this ability to be able to get this drug through telemarketing and through the internet without actually seeing anyone or them being able to verify anything, means that they they cannot confirm the gestational age. It could be beyond the safe limit, or do they have an opportunity to have a sonogram to be able to determine whether or not it is a viable pregnancy or even an ectopic pregnancy. Now, one of the things you haven't considered is when this bill is requiring the expansion and the access to protect the access and critical medication, this is going to make our current parental notification for minors virtually unenforceable. The parents do not know if the minor child has actually gone online and ordered this drug to have, a mail order abortion. And so I think that it's going to be very important that we not pass a bill that is going to enshrine or make the access available for the unintended consequence of having a minor child not involve their parents in their health care. So I would urge you and request that you vote ITL on this bill.
Thank you very much for your testimony, Ms. Wood. Are there any questions from the committee? Okay. Seeing none, thank you. The chair will call Kayla Montgomery and Ms. Canada. Do you want the two of you to come up together? Sure, that's fine.
Thank you, and thank you for allowing us to speak on this together. My name is Kayla Montgomery. I'm the Vice President of Public Affairs for Planned Parenthood of Northern New England. We support this bill. So I'm going to just run through some testimony. It's important. And then I'm going to try and clarify some of the things that have come up, and then I'm happy to answer questions, and then turn it over to my colleague Liz here. So I want to just back up a little bit and explain a little bit more about what medication abortion is. So it's also known as the abortion pill, safe and effective way to end an early pregnancy. At Planned Parenthood of Northern New England, it's up to 11 weeks or 77 days. And that means the 77 days is the first day of your last missed period. And you can always confirm that with an ultrasound. If a patient is 78 days, they cannot have a medication abortion at Planned Parenthood. They could have a procedural abortion. Serious complications happen in less than 1/3 of 1% of cases. It is safer than common medicines like penicillin and Viagra. So at Planned Parenthood Northern New England, medication abortion is provided at 3 out of 4 of our health centers in Manchester and Keene, and as of last month, at our Derry location as well. So we say the abortion pill, but to be clear, it's actually a series of 5 different pills using 2 different drugs. So the first one, and the one that we've been hearing about the most, is mifepristone. The second one is misoprostol. So a patient will take one mifepristone, and that is the drug that blocks progesterone, and that's the hormone that's needed for pregnancy. So that first pill in the series stops the pregnancy from continuing. The patient will then take 4 of the misoprostol pills. They put them in their cheeks and let them dissolve. And this is the drug that empties the contents of the uterus. So this combination, this 2-drug, 5-pill combination is the standard medication abortion protocol. Medication abortion is treated the same way that a procedural abortion is treated, in that it's the same intake procedure, it's the same counseling, it's the same follow-up care. The big difference, of course, is that medication abortion, it actually happens in your home, and procedural abortion happens in the health center. So many patients are choosing medication abortion. Nationally, the number of people who choose medication abortion over procedural abortion is about 50%. But at Planned Parenthood New England, that number is actually much higher. Last fiscal year, it was around 70%. And people choose medication abortion for a number of reasons, most commonly because patients can be in the comfort of their own homes. They feel like they're on their own terms. And some people feel like it's just less invasive. It is not for everyone. And we certainly, every patient that comes through our doors are offered choices. It's personal decisions, whatever works for them. We offer, of course, both options. And I just do want to add, because I think it's important to note, that New Hampshire was actually the first state in the nation to adopt a resolution urging the FDA to allow clinical trials for mifepristone medication abortion back in 1991. So passage of this bill is continuing our long history of supporting medication abortion. And just a couple of things that I want to note before I'm happy to take questions. The first being, I just want to clarify around the New Hampshire Family Planning Program. The New Hampshire Family Planning Program, of course, medication abortion is not a part of it and never has been. Birth control is, which is a part of this bill, but abortion, whether it's medication abortion, procedural abortion, has never been covered under the New Hampshire Family Planning Program, never has been. So I just want to clarify that. Regarding telehealth, so telehealth medication abortion is something that Planned Parenthood of Northern New England started doing about 18 months ago. And it is an option for some people. I would say we've done about, I don't have the numbers in front of me, but probably 7 to 13% of abortions are via telehealth. And that's for all 3 of our states. I don't have the specific New Hampshire numbers. It is not for everyone. Some people would want to do it, and we're unable to do it for them because it's just not for everyone. A patient has to be really clear about when they had their last menstrual cycle. They have to fit a lot of criteria in order to be available for telehealth. And I've heard a few times around going online and ordering pills. So, I mean, to be clear, I represent Planned Parenthood, so I do not know, just like, you all don't really know what is going on online necessarily. I will say that since the fall of Roe, we've seen a lot of these different companies pop up. And of course, they all have to be licensed. Their providers have to be licensed in the state in order to provide medication abortion. Some of them have come and go, but that is definitely something that is becoming more and more popular as the legal landscape has shifted and as access has shifted in this country. But I don't have any, I don't represent those organizations, so I don't know, but I do certainly know how we do telehealth in New Hampshire. And I think a question about follow-up care with telehealth came up earlier too. And if someone does medication abortion via telehealth, our follow-up is the same. We have a 24-hour line. Planned Parenthood, because we are a larger organization, we are able to work with other affiliates throughout the country and have a call center that's open 24 hours. So just because our health center is closed doesn't mean you can't call and ask any sort of question that you might have. Perhaps a patient is experiencing heavier bleeding, or they just aren't really sure what's going on. Patients are told, they can also take pregnancy tests, of course, after a certain amount of time to make sure that the abortion has been completed. And if anyone has any concerns, of course, people can always come in. We can always do an ultrasound on someone. So there's lots of different follow-up care that's available. It's all personalized. It's all, of course, compassionate and trauma-informed. And it's going to work differently for everyone. And then I did hear something around parental notification. I just want to be clear that the law in New Hampshire is clear on parental notification, and Planned Parenthood follows the law.
And I think that's it. And I'm happy to take any questions around this.
Okay, are there any questions? Senator Abbott.
Thank you, Madam Chair. Thank you for taking my question. If the medication's already available throughout the state of New Hampshire, I guess my point is, what is the purpose of this law going forward, having it pass?
Yeah, so I'm actually going to hold on that question because I think my colleague Liz is going to talk a little bit more about what's to come in the next 6 months, and hopefully that'll come up.
That's fine.
Hey, Ms. Canada.
Here I am.
All right, there you are.
Here comes the microphone. Now it's real. Liz Canada, Advocacy Director of Planned Parenthood New Hampshire Action Fund. So I think before I address your question directly, Senator, just want to talk very briefly about the case that's before the Supreme Court now. They just announced that they're taking up that case. It's Alliance for Hippocratic Medicine versus the FDA. So where this came from, a group of anti-abortion activists and organizations sued the US FDA over its approval of mifepristone, the first pill of the series, as Kayla just shared. The case uses junk science to allege that mifepristone was wrongly approved by the FDA 20 years ago. And it's seeking to remove mifepristone from the market entirely. That was the purpose of the case being introduced in Texas. The FDA's approval, as you all know, affects all states, not just Texas and so forth. So it would impact New Hampshire as well. It would also impact states like our friends over in Vermont who've passed a constitutional amendment, who have protected abortion in their constitution. It would affect them because it's about the FDA approval process. That's what this case is about. So the case is politically motivated, it's instigated, it's funded by anti-abortion activists for the purpose of banning abortion nationwide. This is a tactic they are using where, as I shared with you in an earlier testimony, our law in New Hampshire is abortion is safe and legal up until 24 weeks. There are exceptions and so forth. But this would impact mifepristone here in New Hampshire, even though that is our law. It's approved up until up through the 10th week of a pregnancy. And so if the Supreme Court rules in the way that we saw from the lower court, they could roll back that approval process and make it more restrictive in the state. What this bill does, I'm returning back, I'm circling back. What this bill does is direct the Department of Health and Human Services here in the state to identify the gaps. What's happening out there in the landscape for medication abortion and for medications around reproductive health care, asking for, using your own state resources that you have here to identify the landscape. What is going on here so that when the Supreme Court decision comes out, likely in June, just like we saw 2 years ago with 2 years ago, 1 year time, it's 2024 as of today. So 2 years ago with Roe v. Wade, we're seeing that same timeline. So this is a way to get a better understanding of the impact that it could have here, depending on what that Supreme Court decision is, likely in June.
Okay, thank you for your testimony, Ms. Canada. Are there any questions? I'm just reviewing the notes that I have. Of course. So if the federal government says that the process the FDA used was flawed and said, okay, we have to go back and redo this, what does this do to the states that have stockpiled this medication? Because the FDA is saying, wait a minute, this process is bad. What we did was bad. Are we going to allow our doctors to have access to medication that the FDA is now saying was passed and created with a flawed process?
Thank you for that question. It's an excellent question, which is being discussed about this case significantly. So first, it would be coming from the courts, right? It's coming from the Supreme Court. The FDA is not saying we've made a mistake and so forth. They're very clear that they followed all of the procedures that they needed to approve it appropriately and so forth. I don't know what states are going to do in terms of if they've stockpiled and so forth, but I know that providers are going to follow what is the FDA approval process. So if it is rolled back and, part of that process, I think the lower court decision says that it would then be approved until the 7th week. That means that providers are going to follow that. Like that's what they have to do in order to prescribe that medication. And that means for the folks who are now after 7 weeks in a pregnancy, how they can access abortion changes in states where it is legal, like New Hampshire.
Okay, thank you very much. I appreciate your answer. Are there any further questions? Seeing none, thank you both very much.
Thank
And
you.
Thanks for
letting us both
hanging
come
out
up
with
here.
us this afternoon.
We love it. We love it. Thank you.
Thank you. The chair is going to call Patty Loidice, I think the name is. It's Loiodice. She had to leave? Okay. The next person I'm going to call is Fidelma McKenna.
I was wondering if Janelle Hobson can testify with me. She's also on.
I don't believe I have her name here.
Oh, okay.
You just have written testimony, but. Okay, but you would like to come up, okay, that's fine. Just if you're going to speak, just check, make sure you identify yourself for the record.
Okay. Hi, everybody. I'm Fidelma McKenna. I'm a certified nurse midwife, and I'm testifying in support of this bill. This is my colleague, Janelle. One of the reasons it's so important to increase access to this medicine is because it allows us to care for people with uteruses in the most evidence-based standard of care way. I'm a nurse midwife. I work at a hospital. I mostly catch babies, and I also see people in the emergency room. So I want to just tell you a story about Christmas 2023, 2 weeks ago, Christmas Eve and Christmas Day. I was working. I wasn't at church. I wasn't with my family. I was working on the labor and delivery unit because I care about people with uteruses and I care about my patients and their babies. And unfortunately, there weren't any babies coming on Christmas, but I did answer the phone. I do triage as well. And I had the unique, painful privilege to support 3 different patients sobbing and processing their grief as they experience miscarriages. And it is very painful to support somebody through that. And it's equally infuriating when you know that you're unable to prescribe the correct standard of care, evidence-based protocol as per the American College of OBGYN. So they're my professional organization besides the certified nurse midwife one, right? And they say the best way to manage an early pregnancy loss is with mifepristone and misoprostol. To give you numbers, there are several ways to manage miscarriage that can be expectant management and let them process it on their own up to a certain point. You can also support them with medication to help expedite the miscarriage, or you can do a procedural intervention. But a procedural intervention isn't always the safest option. I feel sad because I think that there are some people in this room who are laboring under misapprehensions about that, and they were saying that a procedural intervention is always safer, but it's not. Sometimes with a miscarriage, the pregnancy is already ended, so there's an inflammatory process that makes the uterus more likely for perforation. This is not in an abortion, but this is with a miscarriage. With a procedural intervention, there's sometimes an increased risk of perforation or infection or increased bleeding. And maybe somebody who has fibroids, which are those growths on the uterus that make it harder for the uterus to contract or for the procedure to actually complete it. A medical management is actually better. And sorry, I just lost my train of thought. So I think people were unclear about why we would be pursuing mifepristone and misoprostol, especially for early pregnancy loss. And I think it's a really good example of how politicization and stigmatization of medicine in the reproductive world negatively impacts people with uteruses experience in healthcare. I wanted to give you numbers. Medical management of miscarriage usually works with misoprostol alone 70% of the time. With misoprostol and mifepristone, it works 83% of the time. So when I can actually prescribe mifepristone with the misoprostol to manage my patient's miscarriage, I am increasing the success rate by 13%. So that's 13 people with uteruses out of 100 that I will not have to expose to extra hospital care, extra hospital bills, extra invasive procedures into their bodies. So I think that it is very important to remember that this is a safe, evidence-based standard of care procedure. And when we let politics impede our access to it. And again, I wanted to clarify for you guys, because I'm not sure if you understand, but I can't prescribe that over the phone at my job, even if it's the standard of care, evidence-based, recommended by ACOG, because while it is legal and available in New Hampshire, the pharmacy has to be certified in all these specific ways. And so if I'm talking to someone who's called me saying, I'm losing my pregnancy, I'm bleeding, what are my options? I can't call in the prescription to their pharmacy because their pharmacy probably hasn't done those things. It's typically a pharmacy affiliated with an OBGYN office or a pregnancy or abortion center who has filled out those hoops. So I can't prescribe them the evidence-based care that they deserve because of these extra loops that have been put in. So this medication is safe. It is the standard of care for the people of New Hampshire. And in order to take care of our patients the best, we need to ensure as many restrictions on prescribing this medicine are removed as possible. I want to point out, I work at Equality Health Center as well, and I'm well versed in telemedicine for abortion care. So if you have questions about that, after Janelle speaks, you're welcome to ask me.
Thank you very much for your testimony. Ma'am, could you please identify yourself for the record?
Yes, thank you. My name is Janelle Hobson. I am the Executive Director for the Equality Health Center here in Concord, New Hampshire's longest standing abortion center. And I did submit written testimony yesterday, but I just wanted to touch upon a few things throughout today's hearing. And I know it's late, so I appreciate your time. But we at Equality Health Center have been providing medication abortion for over 20 years. And we do have a process. And what we do with follow-up with our patients after our providers prescribe the medication and they're in the comforts of their home, we have the patient come back in and they have an ultrasound to make sure the uterus is empty. Okay, so there is follow-up after prescribing the medication. So we want to make sure, with the ultrasound, that the visualization of empty uterus. There's also a follow-up after that, 1 month after they come in, and we do a pregnancy test. So I just wanted to point those two things out. Our providers are the ones that dispense and prescribe the medication. We have a limited pharmacy license at the Equality Health Center. We're regulated, obviously. And I just wanted to point out those couple of things. I think it's important to know that your local independent clinic does follow these guidelines, and we are patient-centered.
Okay. Thank you very much for your testimony, Ms. Hobson. Questions? Do you have questions, Senator Whitley? Okay.
Thank you, Madam Chair, and thank you for taking my question. You raised a novel issue for me that I really hadn't thought about in depth, which is another reason why this bill is necessary is these barriers that already exist. So I think, we can think of it both as, protective legislation, but also we do have some barriers in New Hampshire that we need to eliminate, which you've just identified, particularly heartbreaking for people with experiencing miscarriage, that you're not able to do that in a way that potentially is the best for the patient because of some restrictions. So this legislation would enable the department to explore those limitations. And thank you for raising that issue. I'm wondering, you may not know this, but are there other states that have done this better on the pharmacy side or that don't have the restrictions that our department should be looking to?
When I was a medication abortion prescriber in Massachusetts, which is typically on the forefront, it was similar. In fact, I had to have patients sign a consent form saying they were having a medical abortion, even if they were experiencing the tragedy of a miscarriage. And I had to preface them with like, listen, I'm giving you this medicine, and the only way I can give you this medicine is if you sign this Mifeprix consent form. And I apologize because it's right now for you pretty triggering because you're not choosing to have an abortion, you're having a pregnancy loss, but the only way for me to give you this medicine is if you sign this consent form. So for me, having worked in a couple states in New England, what I have seen is a generalized stigmatization and politicization of this particular evidence-based standard of care medicine.
Okay, that's helpful. Thank you.
Are there any further questions? Seeing none, thank you both very much for your testimony. And the chair is going to call Jason Hennessy.
All right. Well, thank you. I understand the precarious position I'm in, being between you and dinner. So I will try to make this as fast as I can. So I'm here to represent New Hampshire Right to Life. We oppose SB 567. And one of the big points is why should we be targeting one industry? So New Hampshire, we're a relatively small state compared to the rest of the states in the country. We have very limited resources, and the question is, why would we want to target these specific medications with our limited DHHS resources rather than taking a more holistic approach? I mean, is this more important than EpiPens, than insulin, antibiotics that might be resistant to new strains? I mean, is New Hampshire like more experienced at managing pharmaceutical stuff than CVS or Walgreens? I mean, so I think we really need to ask the question, is this our area of expertise, A? And B, is this the right prioritization? Second, as we've heard people testify here, whatever we do, if we pass this bill, it won't affect what the FDA does. The FDA will still be binding on New Hampshire. So I'm not actually sure what the bill accomplishes. If chemical abortion is not available, we still have the safe haven laws which have been here for 21 years, which means nobody is required to raise a child they don't think they can. Finally, I think the biggest flaw with this bill is that it does nothing to protect women, and certainly not their children. I brought up earlier the case of Brooke Fisk. She was 17 weeks pregnant with her son Maki, and her boyfriend had told her, I want you to get an abortion. And she said no. She went to go visit him, and he mixed some misoprostol into her tea, and she then went into labor and lost her child. The idea that we should not have any restrictions is going to make this even more possible. In that case, the boyfriend was a doctor who, it doesn't say in the news stories, but maybe got it from his hospital. In another case in Wisconsin, there was an unfortunate case where where mifepristone was mixed into a pregnant woman's smoothie, and then she lost her child. He had obtained it through a connection internationally, who then mailed him the prescriptions. But if we drop all of our requirements from the FDA, who's going to protect from forced abortions? This is a real thing, and there's many other examples of this. So without having in-person requirements, how are our pharmaceutical companies or the distributors going to know that this is actually going to the person who wants to get the abortion? It's a really big issue. Finally, there was a reference to the mifepristone case, Alliance for Hippocratic Medicine versus FDA. I just want to encourage you to read the judge's decision. It wasn't completely baseless. For instance, the mifepristone back in 2000 was approved under a section of the FDA that is for extremely risky things where you're okay with that risk. For instance, a very new medication for cancer where if you don't take this, you're probably going to you're probably going to die quickly. It was approved under that kind of safety protocols where they didn't have to do the full vetting. And secondly, that the FDA sat on that appeal for 16 years. And so, and they basically ignored it, if you look at that case and the merits of it, I think you'll find that Judge Kastmark did a pretty good write-up. And I thank you for your attention and would be happy to take any questions.
Thank you very much for your testimony. Senator Whitley has a question, then Senator Abbas.
I just want to clarify, wouldn't you agree if you read the bill, we are not doing anything to remove protections for the prescription of mifepristone? Nothing in that bill says we're removing any protections, any protocol, nothing. Isn't that correct?
So there is a rulemaking component to it, and what comes out of the rulemaking component is because it asks GHHS to take a look and to come up with ideas. So if there's a rulemaking component in it, then I suspect that could affect that.
Yeah, just a follow-up. Would you believe that there is not a rulemaking component part of it?
I would have to go take a second look at the bill. Thank you, Senator.
Follow-up?
Would you believe that I would rather trust our OBGYNs, our medical experts, our evidence-based research that they're interpreting rather than Judge Kazmierek, who is not a doctor, who is merely a political activist on the court? Would you believe that I would rather trust doctors rather than Judge Matthew Kazmierek?
I could believe that, Senator, but I would also add to that there are many pro-life doctors who are participated in that case. And in their medical judgments, the FDA was wrong.
Okay, Senator Abbas.
Thank you, Madam Chair, and thank you for taking my question. You mentioned two instances where a man put this medication to someone's drink, or a woman ingested involuntarily. In those two instances, was the man charged with any criminal prosecution, or?
Thankfully, in both of those cases, they were charged with fetal homicide, and they were convicted, or one pled, but yeah.
Follow-up?
Do you know what states those were in?
Oh yes, one was in Wisconsin. That was the mifepristone one. The other one took place in Virginia. Thank you for your question.
Are there any further questions for Mr. Hennessy? Seeing none, thank you very much, Mr. Hennessy.
Thank you, Madam Chair.
Okay, are there any other members of the public that would like to speak to Senate Bill 567? Okay, if you could come forward, please, and make sure you identify yourself for the record.
Thank you. My name is Representative Barry Hacken-Phillips. I'm a co-sponsor of this legislation, and I apologize for not being here earlier. We were across the hall attending to legislation in the other chamber. I am here and honored to be with you today to speak about support for SB 567. I'm going to keep my remarks limited to two overall points, giving the really compelling testimony heard today from both advocates and providers before you. So first, I'm here to relay an important constituent story for your consideration. A particular OBGYN and DHMC physician, who is also a professor at the Geisel School of Medicine in my district, who resides nearby, is licensed to practice both in Vermont and New Hampshire. He has reported to me directly that the recent attacks limiting his medical practice in New Hampshire are pushing him to stop offering his provider services in New Hampshire, and in fact, move his clinical practice exclusively to Vermont. He feels that the laws regulating abortion care are an unfair intrusion into his medical decision-making, which follow the national standards of care, and he believes are an intrusion upon his professional expertise. This law, if passed, would provide him an important signal of support that New Hampshire trusts its OBGYN physicians and values their difficult but meaningful work. Protecting vital access to abortion medication is an important part of his clinical work, and passing this bill will assure doctors like him that New Hampshire is serious about giving providers all the tools they need to best serve their patients. An important moral victory after recent attacks on this profession will restore their confidence in New Hampshire legislators, particularly for putting people and their health care before politics. For that reason, I hope you will support this bill. But my second point is that I'm here personally to express my deep disappointment that we even need to expend this much collective energy and these resources to entertain bills like this, protecting women's reproductive health care, without acknowledging, without naming the true discrimination that pregnant individuals in New Hampshire are facing due to the ongoing political attacks. The mere fact that we're not discussing the efficacy and wisdom of protecting male reproductive medications like erectile dysfunction drugs, which for the record are not nearly as safe and not nearly as effective as abortion medication, and demonstrates the true discrimination against and injustice thrust upon women and pregnant people in the state of New Hampshire. This is the point that makes me really filled with rage. Attacks on access to women's health care, but not men's health care, is a blatant discrimination based on sex, and it is substantial government interference on my medical privacy. But even though I'm filled with rage about these recent attacks on my constituent providers and my own health care, I'm dedicated to climbing every mountain, proverbial that may be, to support bills like SB 567 to ensure access to safe and effective medication and procedures for reproductive health care. And for these reasons, I urge you and a bipartisan coalition of your chambers for passage of SB 567. Thank you.
Thank you very much for the testimony this afternoon, Representative. Are there any questions for the representative? Oh, you have one? Okay.
No question. I just wanted to thank you for coming over here so late after a very long 2-day marathon session. So thank you very much, Representative.
There's no place I'd rather be. Thank you.
All right. Thank you very much, Representative. Okay, anyone else? Is there any other member of the public that would like to speak to this bill, which is Senate Bill 567? Okay, seeing none, we're going to close the public hearing. And again, I'd like to thank all of you for being here this afternoon. I appreciate you taking the time out of your busy day to come and talk to us about this issue. Thank you very much. Bye-bye.